I beg your lordship, pardon me, Lord. My lord,
Sometime.
my lord, my mother was in hospital.
Pass over only, sir.
Just 5 minutes time take.
Item number 2.
Item 2, my lord. I am for the OSRTC. The senior counsel and senior counsel SK Patnaik, my lord, is denied for that argument, my lord, and he returned all the file. I now, my lord.
Now meaning what?
By the OSRTC as a return.
Now means what, sir?
My lord, the file has not come to me, my lord. So I will request your prayer.
No, when did you come to know that he's not going to appear?
My lord, yesterday, my lord. The law officer has stated that Solent Senior Counsel is not interested to do all the cases of OSRTC. So he has returned the file.
Return file means what? Where's the file? You don't have the file.
Before the office, my lord. So I pray, my lord, your lordship may grant some time next week or any date, as your lordship convenient.
The notice was not issued. There's some huge number of connected writ appeals. This is connected with the other writ appeals.
I understand.
Oh. What are these matters about? No. Senior counsel must have been briefed by some other counsel, right?
My lord.
A senior counsel cannot appear by himself.
No.
He must be briefed by some other counsel. Who's that other briefing counsel?
He is appearing for OSRTC before
Sir,
that.
I don't know if I'll ask him to ask you the question. I think you're not understood the question.
Mr. Santosh Patnaik is senior advocate.
My lord.
So he must be briefed by some advocate
Seems-
who is regularly engaged by the OSRTC. So, my lord asks you the question
It's that.
that whether the briefing counsel is available or you have contacted the briefing counsel.
He himself was a returner, my lord. Before that. Before he got.
It cannot be, sir.
Senior also. Well, before he declared as senior,
He has associates. He has associates.
Yes, madam. He has asked.
When was he declared senior counsel?
That information.
Sir, whatever system in the bar, are you not aware? Can a senior counsel appear by himself? Unless in Orissa, everything is possible. Mr. Mohanty, tell us, what is the system? I have to get educated. Every day I'm getting educated. So, in all other high courts, sir, no senior can himself appear. He has to be briefed by a non-senior lawyer.
The Wakalatnama has to be filed by.
That's the same system here also, sir. So, can you explain to him? Doesn't seem to understand the question.
He is saying that before he became a senior counsel,
Okay, what do you do, sir? When you become a senior counsel, what do you do?
we file Wakalatnama.
By somebody else? Whose Wakalatnama has been filed?
Se sarla pare,
Who's Mr. P.K. Patnaik has filed, sir? You're not even aware of that.
No, madam, I have no.
I'll pass it over. You find out Mr. P.K. Patnaik and bring him.
Problem.
And ask him to remain present. He has filed Wakalatnama. He has to remain present.
Right.
Yes.
supplementary list item number 3. May I please?
Well, the petitioner claim, my lord, to get the revised scale of pay, my lord, that is the UGC scale of pay, and the learned single judge, my lord, dismiss the case on the ground that it is not a maintainable at here. It is to go to the educational tribunal. Actually, I have quoted that provision, my lord, section 24B. It's the question of dispute whether the petitioner is entitled to grant need. That has to go to the 24B under Education Act, my lord. And there already cases are decided, and earlier 2 times petitioner has approached this court. court has directed annexure 6, direct government to consider. And while they rejected, I have filed the writ application challenging the rejection order. And the single judge stated that the matter has to go to the educational tribunal. The educational tribunal, my lord, I have quoted, my lord. That's provision, my lord. At page 6, I'll have glance writ of, my lord. May I read it?
Yes, please.
At page 6, 24b, adjudication by the tribunal. Tribunal shall have the jurisdiction power of the authority to adjudicate all the disputes and differences between the managing committee or, as the case may be, governing body or private educational institutions or any teacher or employees, such institutions of or the state government or any officer or authority of the state government relating to child evidence or connected to the eligibility, entitlement, and payment of non-payment for grant in aid. Here is the melody. He is the from the beginning getting full salary. He has appointed since 1985. So question grant in aid came into force, my lord, 1992, my lord. See, he has appointed 85 and getting full salary. This is the grant in aid dispute whether now the government has decided 1/3, 2/3, and full.
No, relating to or connected with.
Yes, related to all of grant in aid. My question will I am getting central pay. Government of Orissa has being paying the salary, full salary, and also central pay I am getting. So only the question the UGC granted, the UGC University Commission granted a revised scale of pay to the senior lecturer. And pursuant to that, Government of Orissa also notified. I have annexure 4 and 5. Government notified the persons eligible, and pursuant to that notification, number of lectures are getting, and number of orders are there. I have annexed, my lord, to the writ petition. I have glance. Annexure 6, 7, my lord. And notification also I have annexure 4. Can have glance annexure 4. That notification may be read, my lord. Annexure 4 and 5. And pursuant to the notification of the Government of India, Government of Odisha notified. Annexure 4 and 5. And pursuant to that, number of lectures are getting. I am annexed 6 and 7. And petitioner being a many persons junior to the petitioners. And I have a glance, my lord.
Not so. Even for the director of higher education.
This relates to granting aid. You'll have to that sheet that 24B.
Yes.
24B says all dispute relating to or connected with the eligibility, entitlement, payment or non-payment of granting aid. Once he is an employee of a aided educational institution, he'll be paid through granting aid scheme.
No, he says his salary is not coming from grant in aid.
Yes, ma'am. That the payment aided institution means that is granting aid.
I am, my lord, I have my annexures 2. I am getting full salary. It is not a question of granting aid. Granting aid.
Where are you getting it from?
I am. Yes, my annexure 2. I am getting from the government. No doubt, I am getting from government.
Sir, but once you go before the tribunal, he will not raise any objection as to jurisdiction of the tribunal.
That granting
so what is your problem? You will get at least a forum for adjudicating your dispute.
That is not, my lord, absolutely not. Only relating to granting aid decided at provision. They are not adjudicated. It is a, my lord, I have decided number of cases reported here. And I have annexed. And yearly I have filed this writ petition. And I have glanced annexure 6, my lord. And it's a to my writ petition, my lord. And when the government has never taken any action against inaction, I have filed writ petition. And honorable court with your decision quoted there, my lord, directed to government to take decision, and government rejected. Thereafter file a writ petition. That writ petition has dismissed on the ground that it is not maintainable. You go to the approach of Education Tribunal under section 24B of the Odisha Act. Well, at least see, my lord, the earlier order is there. Earlier order, my lord, earlier order that I have annexed. Annexure 9, at page 46 to my writ petition, my lord. Kindly have glance. Annexure 9, page 46 to my writ petition, my lord. At exact page, my lord, 48, may I read it, sir? Ordering person, page 48, my lord.
No, this is only about disposing of representation.
Yes, my lord. Because when they did not take any action, I filed the writ petition. When they did not take any action on the
Here also you are happy with the representation being disposed of?
No, that I have filed. And then they have rejected, which I have subsequently filed the writ petition. And that petition, honorable single judge decided to go to the tribunal under section 24B of the Odisha Act.
May I pray, my lord? Lord, may grant me 2 days time. I'll take instruction whether at least he is eligible or not. I will verify it.
That I have given number of decisions and also
Not number of decisions. Some decisions were challenged before honorable apexa and that is pending. Don't realize those decisions.
you are challenged, no doubt. Number of cases
That
we have
is
also
not-
filed in the Supreme Court, no doubt. But when you are allowing the juniors to the petitioner, kindly have done, I am giving a judgment, my lord. Pity juniors, 4-year junior to the petitioner, he is getting UGC scale of pay. Whereas I am being a senior, I will divide. My lord, just a minute. No, but I will solve.
So this single judge dismissed it without your counter being filed.
Yes, my lord.
Ah, so on merits you did not have a say.
Your lordship can remand it for filing. We will file a counter there. Or your lordship.
Yeah, that's okay. You see,
If your lordship will give.
the short question that arises for consideration here is whether the learned single judge was justified in relegating the appellant to the educational tribunal, bristle of the grievance voiced in the writ petition, namely that the appellant should be extended the benefit of the UGC scale of pay as applicable to degree college lecturers in non-government aided colleges at the revised rate from 1991 onwards. Full stop. Inter alia, challenge was raised to an order dated 3rd February 2018, passed by the Director Higher Education, Orissa Bhubaneswar, declining that relief to the appellant. Paragraph. In the impugn order, the learned single judge has, after referring to Section 24 capital B of the Orissa Education Act, come to the conclusion that the expression in Section 24 capital B bracket 1 open quotation relating to or connected with eligibility, entitlement, payment or non-payment of grant in aid, unquote, would cover the dispute raised by the appellant as well. Paragraph. Counsel for the appellant, however, points out that the issue raised by the appellant does not concern, open quotation, payment or non-payment of grant in aid, unquote, at all. Full stop. His specific plea is that that extension of the benefit of the UGC pay scale to the petitioner appellant is not an issue concerning the providing of single quotes grant in aid, unquote. He points out that there have been other similar instances where the High Court, in fact, entertained a petition by this very appellant and entertained a petition, that is writ petition civil 19077 of 2007, filed by the present appellant, and by an order dated 13th September 2017, required the Director of Higher Education to take a decision on the appellant's representation dated 19/12/2016. Full stop. In fact, it is pursuant to that order that the impugned order dated 3rd February 2018 was passed. Paragraph. Having heard learned counsel of the parties, the court is of the view that the learned single judge overlooked the fact that it was a second round of litigation arising out of an earlier order of the High Court, which not only entertained the writ petition filed by the appellant, but also passed the aforementioned order requiring opposite party number, the respondent number 2, to dispose of the appellant's representation. Stop. Consequently, the writ petition could not have been dismissed at the threshold without adjudicating the merits of the matter. Paragraph. For the aforementioned reasons, the impugned order dated 10/12/2018 passed by a single judge is hereby set aside. And writ petition civil 15984 of 2018 is restored to the file of the single judge in the roster bench, where it will be listed for directions on 2nd January 2023. Full stop. By 12th December 2022, the Director Higher Education should have filed a parawise reply to the writ petition, and rejoinder thereto, if any, should be filed by the present appellant (writ petitioner) before the date of listing of the writ petition, that is 2nd January 2023. Paragraph: the learned single judge is requested to proceed to dispose of the writ petition on merits in accordance with law as expeditiously as possible. Writ appeal is disposed of in the above terms.
Item number 4.
I mean, pardon my lord, in item 1, I have got the instruction that she is continuing.
She's continuing.
Yes.
Okay. So we allow the writ appeal then. That's what last time I think we were stuck on. We'll pass that order.
Item 4, my please, my lord. The appellant is challenging the order dated 14/12/18 passed by the honorable single judge, wherein honorable single judge has directed the appellant to file appropriate application before the civil court. Let's say page 47, the impugned order. Reading of the sole question resolves around the date of birth of the petitioner. Though the petitioner has filed certain documents stating that his date of birth was 17/2/1963, and initially the same was accepted by the authority, by office order dated 9/8/18, the same has been withdrawn by office order dated 29/9/18, stating that his date of birth was 24/10/1958. Since there is dispute with regard to date of birth, it is open to the petitioner to appropriate civil court to establish his correct date of birth so as to get the benefit in accordance with the law. My lord, the case is that, my lord, lordship kindly glance to the order of appointment. That is, my lord, annexure 1, page 12, my lord. Initially, the petitioner has been appointed as an attendant before the respondent company, and subsequently he has joined on service on 4/2/1987. Thereafter, my lord, he deducted. Lordship kindly, at the time of joining, he has submitted his SLC certificate. There is page 16, my lord, which shows that the date of birth of the appellant is 17/2/1963, my lord. Page 16.
So this SSLC certificate and all has to be proved in the court of law.
My lord, lordship kindly glance to the next page, my lord, page 17.
Yes.
Lordship, while deducting the EPF, the employer has reflected that the date of birth of the appellant is 70/2/16, my lord, in the year 2012.
So this cannot be an authentic proof of your date of birth.
My lord, lordship, I am coming, my lord. And my lord, in 14, it is also 7/2/63. My lord, all of a sudden, in the year 2015, the employer deducted the EPF, mentioning that date of birth of the appellant is 24/10/1958. I raise objection, my lord, page 20. That my date of birth is 7/2/63, it is not 24/10/1958. No action has been taken. Thereafter, again, I represented, and taking a cognizance on my representation at page 22, annexure 6, the office order has been passed, my lord. That is page 22, my lord. After due consideration to the application submitted by you, the management has carefully examined, observed, and decided that the date of birth mentioned in the school living certificate given by you at the time of joining in service is final and binding for all. Hence, as per the SLC submitted by you during the time of joining to the industry on 4/2/1987, date of birth dated 70/2/63 is stands for all purposes of service. Thereafter, my lord, all of a sudden, that order has been recalled. Annexure 7, page 23, without giving me any notice, my lord. That is on 28/9/18. Operating person. However, since an office order divided number such has been wrongly issued to Sri Dakua, changing his date of birth to 17/2/63 on the basis of a Xerox copy of the SLC, it becomes necessary to recall the same in public interest and is hereby recalled forthwith. Thereafter, my lord, on the very next day, I have been issued with notice of superannuation.
No, did you produce only a photocopy or an original?
My lord, lordship, and the internal note sheet, my lord, of the department. That is, my lord, page 27. And page 20, relevant portion, my lord, page 28. With best, starting with my lord, with best efforts, Sri Dakua has submitted his duplicate certificate duly countersigned from Patoli Guda Government UP School. The copy of countersigned SLC may also be perused at page such and considered to accept his date of birth as per SLC for all purpose, or it may be confirmed by physical verification for satisfaction of the management.
So what did they do? Did they do
My lord,
physical verification?
the very next page, my lord, 29.
Yes.
Visited the school with secretary at 10:30 a.m. and verified original TC was issued on 3/12/1986 by TC number such and such dated 3/12/86 on book number 1 is genuine as per certificate produced by Sri Ganapati Dakua. Hence, his date of birth may please be accepted as 72/1963 for all purposes. Thereafter, when an inquiry has been conducted and after verification, the date of birth is found to be 17/2/63, the notice of superannuation that appellant you are going to be notice superannuation dated 29/9/18.
No, but why do they say that you produced only a duplicate?
My lord. And when my date of birth has been changed from 17
No,
to
you produced even in this page 28, it
My
only
lord.
talks of a duplicate certificate.
My lord, even if I produce the duplicate certificate,
What is it even? You don't have the original.
my lord, the employer has verified from the school, and after verification, they found that the certificate is genuine, and my date of birth is 17/2/63. And when my date of birth has been 17/2/63, as per the office order, and recalling the same without giving an opportunity to me.
So why don't you answer the question? You don't have the original. You
My
only
lord,
have
it
a
has been
duplicate.
misplaced. It has been misplaced. That's why I applied for duplicate.
Where do you say you've misplaced it? When did you misplace it, sir?
That date I have not mentioned, my lord. But my lord,
Isn't that
after
crucial, sir?
even if
Have you filed an FIR about the original date of birth certificate going missing?
lordship, I'm citing a judgment, my lord.
Why? Let's first get the facts. 1 minute. Just ask. Let's get the facts. Judgments will come.
My lord, when
Let's just get the facts right, sir.
my lord, when my representation has been duly considered and an office order has been passed to the effect that my date of birth is 17/2/63 as per the SLC submitted by me.
All that begs the question, doesn't it? That's why they have passed this order recalling all of that. It should be based on some authentic document.
My lord,
Their concern is all those orders were passed on the basis of some duplicate documents,
my lord,
and so they have recalled it.
my lord, as per law, admission is the best piece of evidence, my lord. When the
Not matters like this, sir.
employer themselves visited, they verified the genuineness of the documents. Is that my date of birth as per the SLC is 17/2/63? So, my lord, even if I produce the duplicate certificate, question doesn't arise because the employer has verified the genuineness of the documents after physical verification from the school records, my lord. And even if when office order has been passed on 17/2/63 and subsequently it has been changed.
Is it not better than that simply file a civil suit? They'll bring the original school records. The court will pass a decree in your favor and you'll be done with it.
My lord, my submission is that there is no disputed question, my lord, because the employer themselves admitted that my date of birth is 17/2/63. And when the employer has themselves admitted that my date of birth is 17/2/63, there is no, the question of disputed fact does not arise, my lord.
What do you say?
My lord, I'm citing
If you also turn to page 23, the office order.
All right.
First paragraph. ASCA Cooperative Sugar Industry Limited, ASCA adopted rules to determine the age of its employee by medical board. In event they failed to produce school living certificate duly countersigned by competent authority, Sri Dakua attended did not submit any such certificate at the time of his joining in the industry. Sri Dakua was therefore called upon to produce the SLC duly countersigned by the prescribed authority, but he failed to do so. Dakua was once again asked his office letter number such and such to produce original SLC duly countersigned by competent authority on or before 13/4/1994, failing which it should be construed that he had no valid SLC with him, and in such event, he would be deputed to medical board for determination of his age. Sri Dakua did not respond but preferred to go for medical board, which determined his date of birth as 24/1958 after due examination. So this is the
No. When did the medical board do this? What is the date of the medical board's determination?
But I may be excused because this is disposal case. I don't have the entire record, my lord. So I am just relying upon the documents annexed to by the petitioner appellant itself. And so your lordship knows, my lord, this is disputed questions relating to change of date of birth. So it's a civil court is competent, my lord. So my humble submission before your lordship
Why
is
did you
that
give us date without facts? Why?
yes.
What is the date of the medical board's determination, sir?
My lord, my lord, this is the case
One
where
minute, let us ask him. If you do not know the answer, let him answer.
yes, my lord. Because the file is not entire brief is not available.
That is my lord 29/10/14.
So what were you doing, sir, for all these years? In 2014 itself, the medical board found your date of birth to be 1958.
My lord.
You slept over the matter.
My lord, I came to know in the year 15.
How can you come to know, sir? You went before
My
the
lord,
medical board.
Lordship, kindly have a glance to page.
Anyway, what were you doing till 2018? You don't seem to have moved anything.
My lord, in 18, I have been issued with notice of superannuation.
Correct.
By virtue of the recalling
You are
order.
waiting, sir. 2014, you went before the medical board. They told you your date of birth is 1958. You know the inevitable. Once in 2014, you were aware that your date of birth is 1958. You know the date of your retirement.
My lord, when my thereafter, my lord, I have represented. My representation has been considered.
No, when?
Lordship,
So the
kindly have a
question
glance.
is when?
15. My date of birth has been corrected from 24/10/58 to 17/2/63.
Yes.
That is my lord, page 21, my lord. Lordship, kindly have, that is my lord. 18, that has been corrected, my lord.
So it was
18.
corrected in 18.
18, and subsequently, without giving any notice, without giving any opportunity of hearing, it has been recalled,
Yes.
which violates the principle of natural justice, my
All
lord.
right.
Lordship, kindly glance. I am citing the judgment that school document is to be given pride importance.
Correct. That's precisely what sent you the medical board, sir.
And
This is against you then.
my lord,
This judgment is against you.
my lord, when natural justice has not been followed,
You
while
don't
recalling the
switch
office
on.
order,
You
while
are-
recalling the office order, my lord, no opportunity of hearing has been given.
Right.
Lordship, kindly glance to para 11, para 21 of that order has been, my lord. That is to be followed, my lord. And when my date of birth is changing behind my back, I should be given an opportunity. Lordship, kindly,
Did you go before the medical board or even that happened behind your back?
well, para 21 of that judgment, my lord.
So you are not in the habit of answering questions.
Medical board, I have gone.
Fortunately, I was wondering whether you will say medical board also determined behind my back.
My lord, thereafter, my lord.
So you went before the medical board. Medical board found your date of birth to be 1968. So nothing happened behind your back.
Lordship, kindly glance.
Yes.
That after the medical board, I have represented to the authority that my date of birth has been wrongly recorded. And page 20, page 21, my lord.
All right.
And taking into that, office order has been passed, correcting my date of birth from 24/10/58 to 17/2/63.
All right.
Para 21 of that judgment, my lord.
All right. You see, the present appeal has been filed, challenging an order dated 14 December 2018, passed by the learned single judge, disposing of writ petition civil 19214 of 2018, filed by the present appellant, questioning an order dated 29th September 2018, passed by the ASCA Cooperative Sugar Industries Limited. Recalling an earlier order dated 9th August 2018, whereby the date of birth of the appellant was changed to 17th February 1963 from 24th October 1958. Full stop. The learned single judge has in the impugned order observed that since there is a dispute as regards the appellant's date of birth, it is open to the appellant, open quotation, to approach the civil court to establish his correct date of birth so as to get the benefit in accordance with law. Full stop, unquote. Learned counsel of the appellant submitted that it is only after verifying the school register that respondent to society issued the office order dated 9th August 2018, which stated that for all purposes of service, as per the school leaving certificate bracket SLC bracket submitted by the appellant, the date of birth stood changed to single quotes 17.02.1963 unquote. Therefore, according to the appellant, notwithstanding that he may not have produced the original SLC, with the society having with the respondent to having verified the school register on the basis of the duplicate SLC, and noting that the correct date of birth was 17/2/1963, there was no reason to withdraw that order. And maintain the earlier date of birth of 24/10/1958. Full stop. Reliance is placed on the judgment in Shankarlal versus Hindustan Copper Limited, 2022 6 SEC 211, to urge that in issues concerning the correct date of birth, To urge that the principle of natural justice ought to be adhered to before effecting a change in date of birth, and that the appellant should have been given an opportunity being heard prior to the impugn order dated 29 September 2018 being passed. Yeah, that's what. It's only on national justice, correct. Paragraph. In the present case, the court finds that to begin with, the appellant did not produce the SLC, on the basis of which he was claiming his date of birth to be 17/2/1963. Full stop. The perusal of the impugn order dated 29th perusal of the office order dated 28 September 2018 reveals that after repeated requests to the appellant to produce the original C were not complied with, it was construed that he had no valid SLC with him, and it was decided to constitute a medical board for determining his age. Full stop. The appellant then went before the medical board, which determined his date of birth to be 24/10/1958. Full stop. This happened sometime in 2014. After waiting for more than a year thereafter, on 2nd November 2015, the appellant made a representation without making any reference to the determination by the medical board, but relying on a duplicate copy of the SLC and some EPF slips which mentioned his date of birth to be 17/2/1963. Paragraph. It is on these representations that initially an order was issued on 9 August 2018 by the respondent 2, correcting his date of birth as 17/2/1963. Full stop. Paragraph. It appears that subsequently it was realized that the above change had been effected on the basis of a duplicate SLC, which was contrary to the age determined by the medical board. Full stop. It is in those circumstances that respondent restored the earlier date of birth, that is 24/10/1958, and on that basis, on 29 September 2018, issued an office order that, having attained this age of superannuation, that the appellant had attained this age of superannuation on that date. Paragraph. It is indeed well settled that issues concerning date of birth, particularly those raised closer to the time of retirement, ought not to be settled without an authoritative pronouncement of the civil court. So these are disputed questions, particularly since the original of the SLC, which is perhaps the most reliable document, was not available to the appellant. Stop. It may be noticed here that according to the appellant, he misplaced the original SLC, but is unable to inform the court when he misplaced it and whether he lodged an FIR regarding the losing of the original SLC. Full stop. Be that as it may, since there is a dispute concerning the appellant's date of birth, in the absence of the original SLC, the only proper course was for the dispute to be settled through the civil court. Stop. The facts in Shankarlal versus Hindustan Copper Limited, Supra, reveal that the dispute was raised there long before the claimed date of retirement of the appellant. Stop. The facts there are therefore distinguishable. Stop. Here, the appellant had sufficient opportunity to demonstrate his actual date of birth. And when he failed to produce the original SLC, he went before the medical board, which gave a determination of his date of birth to be 24/10/1958. Stop. In the circumstances, the appellant cannot, in the present case, complain of any such determination having been made behind the appellant's back. Stop. He was always aware of the medical board's determination of his date of birth as 24/10/1958. Paragraph. Consequently, the court is unable to find any error having been committed by the learned single judge. There is no merit in the present appeal and it's dismissed as such.
Item number 5.
My lord, item number, my lord, pardon to mention, item number 2.
Not now, sir. Not in between like this.
My lord, your wanted to know when I have returned all the files to the department OSRTC.
When
15 or 20 days back.
So there was sufficient time for them to instruct him. There was sufficient time for them to instruct a new counsel. Why did they not do it?
I pray, my lord, only for Monday, man. Tomorrow, if your lordships.
It's not convenient to us, sir. For you, it is convenient. You're choosing a day. For us, we have a whole board fixed.
My lord.
All right. Counsel for the Mr. P.K. Patnaik, whose Wakalatnama is there on record as appearing for the OSRTC, informs the court that he has returned the papers to the OSRTC more than 20 days ago. So it appears that the OSRTC chose to instruct, what's his name?
Amitabh Tripathi.
Your name?
Amitabh Tripathi.
Amitabh?
Tripathi.
Mr. Amitabh Tripathi, advocate, only yesterday, is it?
My lord.
Or this morning?
No, yesterday.
All right. Only yesterday. And so and also did not give him any papers. Full stop. He therefore seeks an adjournment. List on. February 8th.
Supplementary list item number 5.
This case, my lord, 10 days time may be granted to take instruction from the party because execution case 2 of 16 that is pending in the court of Baripada, and I need instruction from the party what has happened because it is
against
against
the counsel for the appellant who needs time for instructions. List on 22nd February.
Supplementary item number 6.
Being agreed by the order dated 9/1/2019, my lord, this appeal has been filed, my lord, where the disposed of the dispute the writ petition without giving any opportunity, my lord. The grounds I have stated, my lord, for ground number C in para 8, my lord, page 8, my lord. Due to Bharat Bandh, there was a resolution that no adverse order will be passed on the debt dispute. 8/9/2019 and 8/9/1/2019, my lord. Despite the fact the order has been passed without giving an opportunity to the petitioner to defend his case.
No. What is this? Quarters?
Quarters, but this organization is a social organization doing with the philanthropic and social work, my lord. And accordingly, government on the application of the present mission, my lord, the 1 quarter has been allotted in favor of the this association, my lord. So accordingly, they are doing the philanthropic.
How many years, sir?
My lord, 2001, my lord.
No. For how many years was this allotment made?
2001, it was allotted, my lord.
Okay, I'll ask him to ask you a question.
To which date it was fixed?
It was
The tenure of your
no. It was time to time. It was renewed.
renewed.
So
So
on
up to
8/8/2009, they have cancelled. Challenging that order, we have filed the writ application.
In 2009, they have cancelled.
Yes.
Let's.
You have filed the writ petition in 2008.
You know, the
If it is cancelled in
cancellation was
2009,
cancelled 9/9/2008, my lord.
9/9/2008.
8, my lord. Cancellation order. Challenging that order, writ petition was filed by.
But
interim order was granted, my lord.
disposed of in 2019.
By virtue of the interim order,
It was not- it was pending. Yes. When have you got the stay order?
Two 2008. 23/12/2008, you got to stay.
2012/2008, my lord.
What is the ground on which you are saying that you should be continued? It's only a
No, because
allotment.
we are doing social work, my lord. We are not do private. There is no private interest, my lord.
Still you are in occupation?
Yes, my lord.
Yeah, because
By
status
virtue of
court
the
passed
interim
by
order.
this court. What is there in the impugned order to show it is ex parte?
Your lordship, considering the pleadings, my lord, made therein, I am reading out, my lord.
Sorry?
I am reading out the order, my lord. Considering the pleadings made therein.
No. First word you're leaving out.
Heard.
My lord,
There is the order. What is the first word in the order?
first order of
First word in the impugned
yes, my
order.
lord. Hard.
What does that mean?
9/1/2019.
That is my submission about that. I have not attended the court on the by virtue.
What is that to show that you did not attend?
That is-
What is there from the impugned order to show you were not heard?
The first word written in.
Yes, my lord. That is
the
what
order
there, my lord.
itself
I am not disputing
shows-
the word hard it is. That is there, my lord. I am not
You are
disputing. my
reading
lord.
it after I pointed out. Began reading the order, leaving out that word. Your only point in the whole case is that you are not heard. You're leaving out the word
Hard
heard.
means with no reason. Your lordship kindly see the order itself is
What
very
is
much
your
clear.
grievance?
That there is no
No, your grievances that you were heard,
decided
but no reason
petition.
has been given, or your grievances that you were not heard.
It was verbal. It was there, my lord. It is hard, my lord.
Which means you are present.
My submission is not recorded by EB. I have your lordship can visualize, my lord. If I have argued sometime after argument, this order has been passed. It has not been mentioned, my.
Yes. Okay, what is the ground in which his cancellation?
There is no vested interest that he has.
No, maybe.
Yes,
But there must be some valid ground for not renewing his lease, right? It's a license or a lease. What is it?
It's a lease, and the last renewal was granted from 3/7/2006 till 31/7/2008. Thereafter, there has been no renewal.
No. Why? Suddenly you keep granting renewals and suddenly you stop. What does that mean? You have to explain reasons, right?
Yes, this is a non-government organization which
All
had
right.
been granted a public quarter.
All right.
So thereafter, if the government thinks that after
What things means one fine day you think you will simply stop. No reasons. have to be given.
because
The whole writ jurisdiction is to ask the government to explain its conduct. Correct? So one fine day you decide I won't renew.
Had it been under some scheme.
What is the noting in your file, sir? What is the explanation you have for not renewing the lease? If you had never granted renewal, one can understand. You've granted so many renewals. How suddenly one fine day you decide, okay, from tomorrow I'm not granting renewal. There must be some reason, right?
Let me take instructions on that. If there is, because it's
Did you file a counter in the writ petition?
No, my lord, not filed.
No, there is a counter. Sir, all of you are not even reading the papers properly, sir. No assistance at all to the court. You first of all give wrong dates. We have to go on finding out what the facts are.
I don't have the
very convenient. So all of neither will you have papers, will he have papers, but you'll argue the writ appeal.
No, I am arguing from the instructions that I've received.
Very sad, sir. Really very sad. The reason is given in the counter. You have the counter?
No, they have not solved the counter, my. That is my submitting, my lord.
You are now suddenly submitting when I asked you about the counter.
But that is
till now, there is no such submission that you
have copy the counter. I have not received. I have said that I have not received the counter.
That you are saying now when I am asking you to read the counter.
No, that is my intention.
Not prepared, sir. Why didn't you not prepared to argue this case at all? You have not prepared yourself.
The counter
you didn't have your facts right. Now, when I ask you to start reading counter, you say I didn't get a copy of the counter. Just come to page 24. Yes. Charan mission. What does it do, sir?
He used to do philanthropic work and social work.
So you're not general philanthropic work.
Yes.
Why do you need premises for that?
To continue the service to the needy people, my lord, they wanted accommodation. That was the people.
No. What do you do in that? You're providing shelter there to needy people?
Cooking foods, my lord, to distribute in this slum area, my lord.
No, you're using the... Right, sir. Thank God Justice Raman is reading your writ petition. Come to para 3 of your writ petition. What you told us just now and what you've written there.
Your lordship, para 5 I have stated, my lord.
Come to para 3, sir, if you do not mind.
My lord.
See what you have written in para 3.
A philanthropic and social organization registered under body.
No, para 3 of your writ petition.
Writ petition. The organization also undertakes free legal aid services to the poor. Once in a week, free tutorial and coaching from standard 10 to +3 level to meritorious to poor students 3 days in a week, and besides all the.
No, but this is So you're actually providing free tutorials, coaching from standard 10 to +3 level. You provide a library, a reading room. You've left out all this. When I asked you, what do you do? You're not saying these things. You're talking about cooking food.
No, we are
providing
to the people, my lord.
Now I made you read this para 3. Now you're saying no.
No, my lord. No means, man, I am submitting by that we are
all right.
giving service to the poor.
The thing is, you are not prepared in your own case, but we are helping you. So what is this? When this organization is doing such good work, why can't you renew?
With respect, that is the prerogative of the government.
Nothing. You have not dealt with that also. Let's see what you say in your
if I remember, the registered office of this organization, it's actually an organization based out of Bhadra. And the administrative or the branch office is at this particular place in Bhubaneswar, the quarters that they have been allotted. That is just the administrative branch office. My lords may come to page para 4 of the writ appeal.
Where is your para-wise reply to this para 3? Come to your counter affidavit. Come to your counter affidavit.
Yes, unfortunately, I don't.
You don't have. Very good. Excellent.
Petition.
So he doesn't have, you don't have. Very good. Can you file a proper replies? On merits, it should be examined. Yeah. No, his status quo. Status quo continued throughout and continued here also. He's continuing. The challenge in the present writ appeal is to an order dated 9th January 2018, passed by the learned single judge, dismissing writ petition civils 17916 of 2008, filed by the appellant, questioning the non-renewal of an allotment of government quarters in favor of the appellant organization beyond 31st July 2008. So, the learned single judge has, in a cryptic order, observed as under. Just take from there's no page number also in the. There's no page initial, is it, in the writ appeal? Take from annexure 1. But there's no page number in there. Take it from this flag. Paragraph. While issuing notice in the writ appeal on 25th January 2019, this court directed status quo as regards possession to be maintained. That status quo order is continued. Therefore, by virtue of interim orders for the last 14 years, the appellant continues to remain in possession of the said government quarters. Are you regularly paying rent and all that?
Yes, ma'am.
Counsel, the appellant adds that the appellant has been regularly paying rent. It may be noted that on the side of the state, no application has been filed for vacating the status quo order. Paragraph. In para 3 of the writ petition, the appellant has averred that it undertakes open quotation legal aid services to the poor once in a week, free tutorial and coaching from standard 10 to +3 level to meritorious poor students 3 days in a week. Full stop. Besides, the organization also provides library, reading room, accidental help, and also has taken up distribution of relief materials to the victims of natural calamities and fire accidents, unquote. Various other activities of the appellant are also described in paras 3 to 5 of the writ petition paragraph. A perusal of the counter affidavit filed by the by the respondent state in the writ petition reveals that it was not a parawise reply. Full stop. It was only stated that after the first renewal of the lease from 3rd July 2006 to 31st July 2008, it was decided not to continue the license of the agreement since there was an acute shortage of type 5 government quarters and a large number of officers were in the queue for allotment of government quarters. Full stop. Paragraph. The fact remains that the state government did not explain how, after granting renewal of the license from 3rd July 2006 to 31st July 2008, it was suddenly decided not to renew it. Full stop. Even at the initial time of allotment of the government quarters from 3rd July 2004 onwards, there must have been an acute shortage of government quarters to be allotted to the officers in queue. Full stop. Therefore, that could not by itself be a valid reason not to grant a further renewal of the license. Full stop. Moreover, there has been no parawise reply to the writ petition, and in particular the averments in paras 3 to 5 of the writ petition, where the work undertaken by the petition organization has been set out. Full stop. This is required to be answered properly by the government. Full stop. Paragraph. The impugned order does not discuss either the averments in the writ petition or the averments in the counter affidavit. And therefore, this court is unable to appreciate the exact reasons that weighed with the learned single judge for rejecting the pleas of the appellant in support of the prayers in the writ petition. Paragraph. Consequently, the impugned order of the learned single judge is hereby set aside, and writ petition civil 17916 of 2008 is restored to the file of the learned single judge in the roster bench, where it will be listed for hearing on 1st February 2023. Stop. The government will file a parawise reply to the writ petition on or before 16 January 2023, and rejoinder thereto will be filed before the date fixed before the learned single judge. No further time will be granted for the purpose. The learned single judge is then requested to proceed with hearing the writ petition on merits and disposing it off as expeditiously as possible. Will stop. During the pendency of the writ petition, the interim order passed with this court on 25th January 2019 will continue. The writ appeal is disposed of in their work terms.
Supplementary list item number 7.
None appears dismissed.
Supplementary list item number 8.
None appears dismissed.
Item number 9.
None appears dismissed.
Item number 10.
The memo is taken in record, dismissed as infructuous.
Supplementary item 11.
My lord, item number 9 was not
9. Item 9.
Item 9.
In this case, my lord, the single bench order under challenge, which has been basis of this judgment, kindly have a glance.
Tell us what the matter is about, sir.
About that judgment has already been repeated.
Kindly tell us what your writ appeal is about.
Petition
Writ appeal, sir. You are arguing
writ
writ appeal.
is challenging the order of the single court. My lord, that judgment is on basis of a Supreme Court judgment.
So tell us what the matter is about, sir. In a few sentences, can you not describe what your case is about?
Because
We will certainly look into that, sir. In your own words, tell us what your case is about.
Yes. Page 27. The controlling authority under Payment of Gratuity Act, Assistant Labour Commissioner passed an order directing that the appellant will entitle for gratuity. He is working as an instructor, and
where is he working as an instructor?
Instructor. That is in the writ petition I have. And after completion of 25
where is he working, sir?
Appointment order, my lord. That is, my lord, page 7, writ application.
Sanjay Memorial Institute of Technology.
Yes.
I think I should ask my colleague all the questions. He will give me the answers. We will write the judgment. That's better.
That in writ application, the appointment
It is all about gratuity.
Gratuity.
It is all about gratuity.
Gratuity. Only gratuity. And that on basis of the single judgment,
When did the person retire? What did he work as? Where did he work? For how long did he work?
That was already elaborately discussed in the.
Then we'll simply reserve orders, sir. If you do not want to answer questions,
yes.
Basically what you're telling is, you please read the papers, don't ask me questions.
Oh,
no?
Correct. Pardon.
Correct.
Annexure 1.
That is correct, no?
Yes, correct.
So we'll reserve orders then.
Page 20.
Orders reserved.
Page 20, my lord.
Orders reserved. Orders reserved. Any question we ask, you simply say, you read the papers, correct? Don't ask me questions. As the judgment is read. You see, despite service of notice, none appears for the respondent. You see, the present appeal is directed against an order dated 18 December 2018, passed by the learned single judge, allowing repetition civil 2929 of 2018, filed by the respondent Sanjay Memorial Institute of Technology (SMIT), challenging an order dated 29th June 2018, passed by the Appellate Authority under the Payment of Gratuity Act, PG Act, whereby the appeal filed by the respondent institute had been dismissed and an order passed by the controlling authority under the PG Act, come Labour Commissioner Berhampur on 23rd February 2013, allowing the claim of the present appellant and directing the institute to pay his gratuity amount, was affirmed. Stop. The net result is, by the impugned judgment, the learned single judge has upheld the claim of the respondent that the present appellant, who was employed as a welder instructor, was a single quotes teacher, unquote, and therefore not covered under the definition of section 2 small e, read with section 4 of the PG Act. Stop. Paragraph. In arriving at the above conclusion, the learned single judge has placed extensive reliance on the judgment of the Supreme Court in Ahmedabad Private Primary Teachers Association versus Administrative Officer 2004, 1 ACC 755. Paragraph. What was perhaps not brought to the attention of the learned single judge was that, consequent upon the above judgment, the Parliament amended the PG Act on 31st December 2009 with retrospective effect from 3rd April 2007, 3rd April 1997. Full stop. By the said amendment, the definition of single quotes employee in section 2 bracket E of the PG Act was amended by widening the scope of the expression single quotes employees to include teachers in educational institutions. Full stop. The amended definition of section 2 bracket E read as under. Paragraph. The error in the earlier judgment in Ahmedabad Private Primary Teachers Association versus Administrative Officer was acknowledged by the Supreme Court in its judgment dated 7th March 2019. In civil appeal number 2530 of 2012, bracket Birla Institute of Technology versus the state of Jharkhand. Where it was categorically held as under. Take from paras 28. B to B. It is therefore now plain that in light of the amendment to section 2 bracket E of the PG Act, with retrospective effect from 3rd April 1997, the claim of the appellant has to be allowed. Full stop. Accordingly, the impugned judgment of the learned single judge is hereby set aside. And the order dated 23rd February 2013, passed by the controlling authority under the PG Act - Assistant Labour Commissioner Berhampur, allowing the claim of the present appellant, is restored to file. Stop. The amount now be paid to the appellant within a period of 8 weeks, failing which it will be paid together with simple interest at 6% per annum for the period of delay. The appeal is allowed in the above terms.
Supplementary list item number 11. Item number 11.
None appears dismissed.
Supplementary list item number 12.
My lord, last week, by the order dated 2/11, lordship directed to tag this writ appeal along with another two other writ appeals. And to that effect, order has been passed, but wrongly it has been listed today, my lord.
All right. When is it?
Last week, order was passed.
When is it coming up now?
My lord, 22nd February.
All right. List on 22nd February. All right.
Item number 13.
None appears dismissed.
Item number 14.
May I please, your lordship, no instruction.
No instructions dismissed.
Obliged.
Item number 15.
Well, I am for opinion over 3 months. All right. None appears for the appellant. Dismissed.
Item number 16.
Number 16, Lord, in this, I challenge the order of the Honorable Single Judge who has dismissed my writ petition, wherein I had challenged the order of the revisional authority, revenue revisional authority, where my property, which was recorded in my name, had been directed to be recorded in the name of the state government. But we hear the short question here, Lord, which was pointed out before the Honorable Single Judge, is that whether an order under the OA Act will be binding on the settlement authority who was hearing the revision. That your lordship will get at para 7 of the impugned judgment. The Honorable Single Judge has pinpointed the question.
Yes.
Lord, in paragraph 7 of the order, thus being the situation, only question that remains to be decided is whether the orders passed by the collector Puri to settle the land in favor of the father of the present petitioners shall have any binding effect to any person. This is the short question. Then he relies on Brindavan Sharma's case and says the entire transaction is wrong. Lord, my humble submission before your lordship is that the Brindavan Sharma's case is wholly inapplicable to my case, because my case is a case of purchase. It was originally in the name of the landlord. He transferred it to a US citizen, and thereafter he transferred it to a trust, and trust transferred it to me. And your lordship will see Annexure 6, with the collector's order, which the Honorable Single Judge has referred. I'm sorry, Annexure 2, my lord. I'm sorry. Annexure 2. This is my vendor's order. This order shows that it was settled in my name. And accordingly, the Tahsildar has certified that I am in possession at page 40, Annexure 5. Under these circumstances, relying on Brindavan Sharma's case, your lordship has seen many times the judgments, that judgment, where the allegation of fraud is there. Where the allegation of fraud is there, then only the entire case is vitiated. But here the question was whether 5I, whether the Board of Revenue's approval was required under 5I. But here it is not a case like that. Here it is a question of purchase. I have purchased the land. The question is, has the settlement authority any power to annul this Annexure 2, which had been passed way back in 1965?
settling the land in my favor.
What is happening on that land now? There's a residential property, is it?
Position of the property. Property is in my possession.
Because there's no interim order by the court.
No interim order here. No interim order here. But they have not taken any steps for
All right.
taking over the.
Yes, who's for the state? Yeah, tell us.
As the single judge, my lords, has decided to pass this impugned order on two grounds, my lords. First, my lords, that under the OEA Act, my lords, the Tahsildar is the authority, my lords. And this order, my lords, has been passed by the collector, my lords. So therefore, my lords, that is without jurisdiction. The second, my lords, is under the OEA Act, under my lords, if my lords sees section 7(1)(a), if I may read the part from the impugned order itself. Certain other lands in khas possession of intermediaries to be retained by them on payment of rent as assets having occupancy right. On and from the date of vesting, all lands used for agricultural or horticultural purposes which were in khas possession of an intermediary on the date of such vesting. So therefore, my lords, the land has to be used for agricultural purposes. And admittedly, my lords, here, there is no document to show that they were, my lords, cultivating on this particular land, and that is, my lords, clear from the impugned order. My lords will find it page 28, my lords. If I may read the first line, my lords, it's the paragraph starts from 27.
Yes.
It relies on a judgment of the Honorable Supreme Court in State of Odisha versus Nityanand Satpathy. The Honorable Supreme Court, interpreting Section 7 of the OEA Act, has held that for the purpose of taking benefit under the provision of Section 7(1)(a) of the aforesaid Act, the intermediary must be in cultivating possession of the land suit land either by himself with his own stock or by his own servant or by hired labor or with hired stock. The nature and character of the land being non-agricultural, the same evidently was not in cultivating possession of the intermediaries, and thus an application for settlement of such land by the intermediaries purported to be in the terms of Section 7 of the Act was not maintainable. Furthermore, the land being not used either for cultivation or horticultural purposes on the date of vesting did not attract the provision of Section 7 of OEA Act. Para 9 minutes. It is borne out from the records that nowhere the father of the petitioners claimed that the land had been recorded in his name by the ASO was in fact used for cultivation or horticulture, and that he was in possession of the same on his own and was used for the use of cultivation. No pleadings have been raised or no evidence has been led to the effect that on the date of vesting, the land was in cultivation possession of the intermediary or anybody acting under him. The order passed by the collector in giving settlement of the land in favor of the father of the petitioners will not convey any title. Since the order passed by the collector is wholly without jurisdiction, the settlement authority at the later stage can ignore the same and record the land in the name of the state government. So the court finds no cogent material to differ with the findings recorded by the learned commissioner. So
there's nothing to show they're cultivating the land.
No, Millets.
Annexure 2 is Annexure 2.
Yes.
Annexure 2, page 29.
Yes.
That itself shows that it is Nicha's land. The Lordship must see. The settlement order, that is Nicha's land means self-cultivation.
No, that must have been in 1965.
65. And I am following, and there is no material to show that in between something else happened.
No. It's the other way around, sir. Because you have to show that you are still cultivating the land.
Yes. And the certificate of the Tahsildar also shows that I am in possession. And
cultivating. See, I think you're missing the point.
Cultivating possession.
Pointed out is that must be material to show that you're still cultivating the land.
So Nicha's land means self.
This is just an entry. It's not. Doesn't tell us the status quo on the date of the decision of the single judge.
Then, my lord, subject to your lordship's consideration, my humble submission would be that he should have inquired into the matter.
No. He's not an inquiry. The learned single judge is not inquiry.
Not honorable single judge. No, the original authority, the revisional authority should have found out what is Nicha's horticultural land, or then come to a finding. There is nothing on record to show that it is otherwise. I understand that there is no material either way.
You have not produced, even now, during the long pendency of this writ petition, now writ appeal.
Yes.
You have not produced any material.
Except these documents, I have given all the documents which I have in possession.
Correct.
So this order, whether it will overlap
the settlement itself becomes questionable if you are not cultivating. You want the settlement order to prevail, correct?
That order has never been challenged on any count. Either it is not horticulture or agriculture, nothing. So many years it has remained unchallenged.
Because this Nityananda Satpathy anyway applies. Even if Vrindavan Sharma does not apply.
Yes.
Nityananda Satpathy definitely applies.
Nityananda Satpathy means, yes, I quite agree. Section 1 shows that.
Yes.
7 reads that it should be cultivating possession.
That's one of the
My humble submission is there is no contrary material except this.
No, it's the other way around. So you are asserting that you have a valid title, right?
Yes, but I have shown my document. There is no counter that it is not, or it is non-agricultural. That means some house is there or something is there. Nothing, no inquiry, no evidence on that point.
Counter has been filed in the writ petition.
Yes, Lord. Counter has been filed.
Yeah. Anything else, sir?
Yeah,
because the counter clearly says that it was sold to one Evans.
Yes.
That deed was never cancelled.
That lease was never cancelled.
Without cancelling the deed, in 1966, another sale deed was executed by your vendor. in your favor.
No, in between there is a settlement deed. Your Lordship may see my debt chart at page 5. On 3/2/21 at page 3, page 5, 100 acres were sold to at the first go. Then this Evans sold some purchased lands to others, and Evans through his authorized agent sold the balance to Yoga Ashram.
Even the deed of settlement, the property only went to Evans under the deed of settlement. It didn't go to you.
But then the Evans through his authorized agent sold the balance portion to Brahmananda Yoga Ashram, whereafter said ashram continued to be the exclusive position. And from ashram I have purchased.
No, but that settlement in favor of the ashram is the problem. That ashram thing could not have been done by the collector.
That's right.
It can only be done by the Tahsildar.
But
He's the Tahsildar,
whether at that point of time, that has remained unchallenged for so many years, that who is the authority? There is that authority that there is, it is not horticulture. On no count it was challenged.
Yes. The challenge the present appeal is to an order dated 1st July 2019 passed by the learned single judge, dismissing the appellant's OJC number 3962 of 1994. Affirming an order dated 18/2/1994 passed by the Commissioner Land Records and Settlement Orissa Cuttack in revision petition number 33 of 1989. Paragraph. The background facts are that the petitioners are the successors in interest of late Debendranath Datta. Stop. In year 1925, one W.E. Evans of USA had purchased more than 700 acres of land, which included the suit land, from one Sri Sadhu Charan Singh, Chand, Sadhu Charan Chand, by a registered sale deed. Full stop. Between 1930 and 1940, Evans sold some portions of the acquired lands. Stop. In 1944, Evans, through his authorized agent Rishikesh Mishra, donated land measuring 100 acres to a registered settlement deed in favor of Brahmananda Yoga Ashram, Marfat Bimal Charan Chand, who remained in exclusive possession of the suit land. Stop. Inside 1966, by a registered sale deed dated 9/12/1966. Bimal Charan Chand sold Sabik plot number 881 measuring AC 79.08 decimal and AC 1.28 decimals respectively to the predecessor in interest of the present appellants, that is Debendranath Datta. Under the Orissa Estate Abolition Act, the entire land vested with the government. under section 7 bracket 1 of the Orissa Estate Abolition Act. (1951). Seven one bracket small a, the OE Act. No settlement of land vested in the state can take place in favor of any intermediary unless such intermediary is in cultivating possession of the suit land, either by himself with his own stock, or by his own servants, or by hired labor, or with hired stock. Stop. Paragraph. The case of the appellants was that they had purchased, that their predecessor interest had validly purchased the suit land by a registered sale deed dated 9th December 1966. And therefore had valid title. Full stop. The learned single judge. No, full stop. It appeared that initially the assistant settlement officer, bracket ASO, on the basis of the entry in the tenant register in favor of the father of the present appellants, recorded the suit land in his favor, ignoring the objections of the state, submitted to the through the Tahsildar Nimapada. So against that order of the ASO, appeal was filed before the additional settlement officer Puri, which again came to be dismissed by an order dated 8/12/1987. Full stop. Thereafter, when a revision was filed before the Commissioner, Land Records and Settlement, Orissa, it was held that the settlement of land in favor of the father of the appellants by the collector Puri and not by the Tahsildar Nimapada was without jurisdiction. And therefore, no valid title could be created in favor of the father of the appellants. Paragraph. While there is force in the contention of Mr. Mohanty that under in terms of the judgment in State of Orissa versus Brindaman Sharma, 1995 Supplementary 3 SEC 249, the prior confirmation of the Board of Revenue was necessary only for transfers other than by way of sale. The fact remains that in terms of the judgment in State of Orissa versus Nityananda Satpathy, 96 bracket 2003 CLT 720 bracket SC, for taking benefit of section 7 bracket 1 bracket A of the OEA Act, the intermediary had to be in cultivating possession. Paragraph. In the present case, it is seen that which is the page you referred to, sir, where that of 1965 you were referring
That Annexure 2.
No, not Annexure 2. Yeah, correct.
The Annexure 5, the Tahsildars.
No, Annexure 2. While Mr. Manthi referred to
page 29.
A communication addressed to the Anchal Adhikari Nivapada by the Deputy Collector in charge, Puri. What's the date of this letter, sir? It's not clear.
The next page. 3/4/1956.
It can't be 56 because there's a reference in the reference to your letter.
That I was wondering, that must be 65. That must, I don't know. It doesn't make sense because it must be 65. Must be.
But even that, because this letter, your letter dated 18/11/65.
65.
That can't be, or even if it's 65, it can't be 3/4/65.
Date is something wrong. Even if this is read as 56 also, it will not correlate.
Communicating settlement of 100 acres. In favor of Bimal Charan Chand. That by itself will not confirm the cultivating possession of the predecessor in interest of the present appellants. Stop. Mr. Manthi then submitted that an inquiry ought to have been held to find out if, in fact, the appellants were in cultivating possession. So stop. The fact remains that during the long pendency of the writ petition for almost 25 years, and even during the pendency of the writ appeal, the appellants have not been able to produce any materials whatsoever to show that they were at any point in time in single quotes cultivating possession unquote of the lands in question. So that being the essential prerequisite for grant of any settlement in their favor in terms of section 7 bracket 1 bracket small a of the OEA Act. The appellants could not have succeed before the learned single judge. Paragraph. With the jurisdictional facts being against the appellants, the court is unable to find any error having been committed by the learned single judge in dismissing the appellant's writ petition by the impugned order. Consequently, the court finds no ground to interfere in the present appeal. The appeal is dismissed. The interim order is vacated. There is no interim order. Okay. The appeal is dismissed. All right.
May I pardon item number 13?
That's all allowed. That substitution is allowed. Right.
May I pardon item number on behalf of Mr. Suljakanta Das. 1 week time allowed to the petitioner for written notes and dead.
Sir, we've already passed the order.
No.
Yeah.
Item number 17.
No instruction. No instruction.
17.
Counsel, the appellant says no instructions. Says yes, no instructions.
Item number 18. Item number 18.
We have put the opposite for it.
None appears with the appellant dismissed.
We are for the respondents.
Supplementary list item number 19.
My lord, please allow one more time.
For what?
My senior is ill, so that he cannot come today.
His senior is ill.
Hmm.
Counsel for the appellant stated to be unwell. First March. Defects be cured in the meanwhile.
Item number 20.
Please, your lordship, my lord. The matter relating that prawn gheri, my lord. And the honorable single judge directed to go to the civil court. Therefore, I have filed this appeal, my lord.
It's better to go to the civil court, sir.
Civil court, it will be governed by the order of your lordships in the PIL, my lord.
All right.
Your lordship may.
The civil court will apply that, sir.
The civil court, my lord, Dixon cannot give in, my lord. Because
What?
your lordship is adjudicating the matter, your lordship may.
No, adjudicating is not. We're not actually settling title and all that.
No, title is there with it. Therefore, my lord, your lordship is adjudicating the matter that whether Coastal Aquaculture Authority Act, it will govern by that, my lord. If your lordship held that permission can be granted, permission will be granted by the aquaculture.
No, what was the issue for the single judge?
That they are cultivating the prawn in the petition is cultivating prawn in his own land. It comes under that Bhitarka sanctuary area near to that, my lord.
Within the reserve forest area.
No, not within.
And
not
he
reserve
says
forest.
that I am doing prawn culture in my private
Yeah,
land.
20 kilometers
That is
away
why the
from-
learned, honorable single judge said if it is a private right title interest holder.
Civil court cannot decide, my lord. Civil court cannot. Your lordship will decide the matter. I pray, my lord, your lordship set aside that order and tag this matter along with the PIL, my lord.
No.
That will be by
PIL become a huge batch, sir.
This writ will be adjudicated by in the PIL, my lord. If I will get the permission from Coastal Aquaculture Authority, then I can do. Unless I cannot do, my lord.
That factual determination has to be done by the agriculture
authority.
Yes, ma'am.
Civil court cannot do, my lord.
Yeah. All right. The challenge is the present appeal. Still, we send it back to the single judge and then take notice.
My lord, your lordship can tag this writ appeal with that.
No, but
I have already
not
read
mere
that.
tagging will not help. The pleadings have to be complete. No, are pleadings complete in the writ petition?
Writ petition pleadings have been completed.
Completed in writ appeal, I have filed and
Counter is not necessary in the writ appeal. It is
I have filed.
No, in the writ petition, there's no counter.
In writ appeal, I have filed a counter affidavit.
Writ appeal, my lord, counter, your copy has not been served on me, my lord, counter. It is not necessary.
Copy is already served. And
No, copy has
many times you have said that copy not served, but it is served.
No, it has not been served. It has not been served. Counter is not necessary. Whether this matter will go to the civil court or will not go to the civil.
No, but are you within that 5 kilometer boundary or you're not within that prohibited zone?
I am not
Yes.
within the prohibited zone. It will be decided unless that permission is necessary from the coastal.
That is the counter of the DFO that it is within the prohibited zone.
Then permission is necessary. I have applied for permission. It will be decided by my coastal
And
agriculture.
if permission is obtained, he will do. So what is the necessity of?
No, they are
keeping
not
this
giving.
matter
In
pending?
spite of my lord, your lordship direction again and again. Till date, they are not granting permission. They are not deciding the matter at all.
After getting permission, you are not allowed to do the prawn culture.
Permission is
Then you can again approach the court.
In number of cases, your
Why
lordship
do
directed
this
Coastal
happen pending?
Aquaculture Authority to grant permission to decide the matter. The applications are pending. Till today, the number of applications are pending. They are not deciding it.
No. When you went before the single judge, had you applied for permission? You did not.
At that time, it was not. Subsequently, my lord, they called for the application. We have filed it before.
So why don't you withdraw the writ petition? So we can permit you to withdraw the writ petition. Then you apply for permission.
I will have to appraise my lord.
You say
yes. That will solve the problem.
At the outset, the challenge in the present writ appeal is to an order dated 6 September 2019, passed by the single judge, disposing of writ petition civil 16180 of 2019, filed by the present appellant, by relegating the appellant to the civil court for adjudication of the dispute raised by the appellant. Paragraph. Before the learned single judge, the prayer by the appellant was for a direction to the opposite party, not to demolish, open quotation, the prawn farm and ponds, unquote, situated on the suit land in Rajnagar Tehsil. Full stop. The entire issue of the claim of the appellant was that he was cultivating prawn in his own land and that it was not within the prohibited zone. Paragraph. Mr. Mohanty, learned counsel for the appellant, states that at the time that the writ petition had been filed, the legal requirement of the appellant having to apply to the Aquaculture Coastal Authority.
Yes, my lord. To DLC first, my lord. Aquaculture Coastal Aquaculture Authority through DLC, district level
Aquaculture
committee.
Coastal Authority through the district
level committee.
District level committee
Kendapara.
had not been put in place. Full stop. He therefore states that he may be permitted at this stage to withdraw the writ petition.
My lords, in my counter affidavit, I have specifically mentioned that it is within 5 kilometers radius of Bhitarkanika National Park.
That will be decided by the
observed.
You see,
That
in
may
the
be
writ
observed.
petition, yeah,
Yes, that may be written
in the writ appeal. A counter affidavit has been filed by the state.
DFO, District Forest.
Yeah,
On
by
behalf of the
District
Forest Department.
Officer, on behalf of the states, averring that the suit land is within a 5-kilometer range of the Bhitarkanika National Park.
Bhitarkanika National Park.
Yeah. And therefore lies in the prohibited zone.
Prohibited zone.
Paragraph. Be that as it may, the court view that these are issues to be determined under the current legal regime, not by a civil court, but by the Coastal Aquaculture Authority.
Yes.
Which will make a factual determination of the exact location of the suit land and whether permission should be granted.
Yes.
For cultivation of prawns therein. Full stop. In the view of the matter, acceding to the prayer of Mr. Mohanty, the writ petition itself is now disposed of, is withdrawn with liberty to the appellant of the petitioner to approach the authorities in question for permission in accordance with law. This order will therefore be in substitution of the impugned order of the learned single judge. Stop. The writ appeal is disposed of in the above terms.
Item number 21.
May I please, your lords. The petitioners are the teaching and non-teaching staff at a high school. School was established in the year 1986, received the minimum grant on 1st of March 1991, and full salary cost with effect from with effect from 1/6/1994. But the order of receiving the full salary cost with effect from 1/6/1994 has been communicated from in the year 1995. In the meantime, state government took a decision that all the institutions, high schools, who has in receipt of the full salary cost with effect from 1/6/1994, those institutions shall be taken over by the government. Accordingly, the petitioners made passed a resolution and requested them that our schools may be taken over as per the terms of the policy decision of the state government. The policy decision is at Annexure 4 of the present writ appeal that was also filed in the writ application, taking over all non-government fully aided high schools by the state government. And the requirement is paragraph 4. Further, management may also be asked to obtain written consent of each approved regular teaching non-teaching staff of existing their roles as on 7/6/1994 to the effect that they will be abide by the conditions of service. And since nothing was happened, I filed a writ application before this honorable court. That writ application was registered as OJC number 2722 of 2000.
2922.
2922 of 2000, and that has been disposed of. And I have quoted the order, Your Lordship, in my writ petition at page 9, paragraph 12. My Lord. And the relevant paragraph I am placing in the above view of the matter, page 10. Above view of the matter, applying the principle of doctrine of non-traverse, the writ petition is disposed of, directing the state authorities to take over the school in question in accordance with the law in view of the government circular under Annexure 2. What I have placed before Lordship. Then they filed a review petition in that writ application. That review application has been rejected. That is the review number 211 of 2018. The order passed on 22/4/2019. The relevant portion of the order is, this review petition has been filed on 15/10/2018 after long lapse of more than 3 years, just when the petitioner filed the application for contempt, alleging non-compliance of the order of this court. As such, this court issued notice in the contempt petition, and on receipt of the notice, this review application has been filed in order to frustrate the order passed by this honorable court and also frustrate the claim of the petitioner. Hence, the review petition has been dismissed. Then when I filed a contempt petition, they filed a compliance certificate that we have complied the order. That instead of complying, taking over the management, they took a stand. In a similar case, the Honorable Supreme Court has passed an order. Taking over is not a matter of right. Taking over is not a matter of right. Their claim has been rejected. Your Lordship may kindly have a glance to Annexure 8. That is the order they have passed. Page 43 of the brief.
Yes.
The Honorable Supreme Court of India, in their order dated 16/2/2010 in civil appeal number so-and-so, Director Elementary Education and another versus Dibakar Pradhan and others, have observed as follows. It is in the discretion of the state government to take over the school or not. It cannot be compelled to do so. After all, taking over the school has financial and other implications. My Lord, I have got the order of the Honorable Supreme Court. Your Lordship may kindly have a glance to that order. That is in respect of colliery schools where there was no principle decided. Here the state government has laid down a principle in 1994. Whichever school has received the grant in aid, as on 1/6/1994, those schools shall be taken over. But that in that Supreme Court judgment, Your Lordship, I am placing had learned counsel for the parties. This appeal has been filed against the impugned judgment of the High Court of Orissa, Cuttack, dated so, passed in OJC number so. By the impugned judgment, the High Court has directed the state government to take over the primary school, Hindi primary school, situated in different collieries of Mahanadi Coalfield Limited. That is the issue. With effect from 1st of April 2000. This direction seems to have been given in view of order of this court dated 3rd December 1999, passed in civil appeal number so. We have perused the said order. In our opinion, the direction in the aforesaid appeal was given solely on humanitarian ground and not any principle of law, and hence it is not precedent. Apart from this, there is no statute which directs the state government to take over all the primary school, Hindi primary schools situated in different collieries of Mahanadi Coalfield Limited. In our view, the court are meant only to enforce the law. It is to exist.
Here you're relying on a different policy.
My Lord, the policy, Your Lordship may kindly have a glance to Annexure 4 at page 28. This is a letter issued by the Government of Orissa School and Mass Education Department. I am directed to say that government have decided on 7/6/1994 to take over all the non-government high schools in receipt of full salary cost, to implement the government decision in the management of the concerned institutions, may be informed to pass unanimous resolution, if they so desire, to hand over the management of their respectively institution, along with the approved teaching and non-teaching staff, including all assets as on 7/6/1994 to government. It should be made clear that the government will take over,
not
take over any liability, whatever, while taking over the management of the institution. Further, the management may also be asked to obtain written consent of each of the approved regular teaching and regular non-teaching staff existing their roles as on 7/6/1994 to the effect that she will abide by the conditions of service applicable to the government servant in all matters.
So you say this order therefore does not apply?
Therefore, it not apply. And the Annex 2 and 3 are the government approval. They have approved our service with effect from 1/6/1994. If we are staff as on 1/6/1994 and we are willing, we have submitted our resolutions.
What happens? Many of you have now superannuated.
No.
In the writ appeal, just come to the cost title.
No. The Shyam Kumar Behra headmaster has been superannuated. Lalit Mohan Satpathy, he has been superannuated. But others are continuing.
No, what will happen as far as 1 and 2? It's infructuous.
1 and 2, if the school will be taken up, school will be taken up at the relevant point of time, they may get some financial benefit. Otherwise, they may not get any financial benefit. 1 and 2,
what financial benefit?
The moment in a aided school, there is no provision for grant of pension. The moment it will be taken over to the government, then they may get some pensionary benefit.
All right. Yes, what do you say?
Annex 9, page 45. London single judge rightly rejected. This is the discussion of the state government to take over a school.
No, this case, the judgment does not apply, sir.
Yes, ma'am.
This judgment of the Supreme Court is in some Mahanadi Colliery schools. Colliery schools has nothing to do with this granted aid schools. The state government has said it will take over.
Yes, ma'am.
So this order of the Supreme Court has no application. That seems to be the only basis for rejection of the writ petition. And this was the second round of litigation.
First round of litigation, the Honorable Court directed to take over. Once the court has directed a takeover and the review petition has rejected, there is no scope. That order has already attended its finality.
Correct. Want to write this order? This application, the writ petition had to be allowed. We allow the writ appeal. Detailed order will pass.
Item number 22.
None appears dismissed.
Item number 23.
None appears dismissed.
Item number 24.
Item 24. But item 24, I challenge an order of the Honorable Single Judge, wherein after considering my case, the Honorable Single Judge has directed that I should go up in 15B, challenging the ROR, because ROR has been published. Lord, at the outset, Lord, the order seems to be innocuous, but the question is that all my records which are there, he has said, considering the innocuous pair, this petition is disposed of with observation. If the petitioner files a revision with an application for consideration, the commissioner shall do well to dispose on merit.
Being uninfluenced. Being uninfluenced. Correct.
Lord, only I pray, Lord, all the contentions which I have taken.
Obviously, sir.
Lord, because
you say the impugned order
without being influenced by this, sir,
has permitted the appellant to file a revision petition under section 15 (b) of the Orissa Survey and Settlement Act before the Commissioner Land Record and Settlement Orissa. Full stop. It has further been clarified that the said commissioner would decide the issue on merits uninfluenced by the order passed by the Assistant Settlement Officer. Paragraph. It is further clarified that it will be open to the appellant to raise all the contentions urged in the writ petition before the commissioner in accordance with law. This is if he is not already disposed of.
No, it has not been disposed
Okay.
of. Only
The above direction clarification has been granted only because Mr. Ramakant Mantil and senior counsel states that pursuant to the order of the learned single judge, the commissioner is yet to dispose of the revision petition filed by the.
only that direction to.
Have you already filed or you've not
No,
filed?
that's what I'm saying. Your Lordship may kindly.
No. Where's the question of now permitting you?
Because because the writ appeal was pending, that's why.
Oh, acha. We had stayed the order. The time limits granted by the learned single judge by the impugned order will begin to run from today.
Obliged.
The appeal is disposed of. The interim order is vacated.
Item number 25.
Item 25, kindly permit me withdraw.
Dismissed as withdrawn. All right.
Item number 26.
None appears dismissed.
Item number 27.
None appears dismissed.
Item number 28.
May I please, your lords? In this case, my lord, the petitioner along with two others were appointed as the legal assistant in OSHB in the scale of 950 to 1500 on ad hoc basis. They continue for the ad hoc basis. You know, see, on 22/1999, the legal assistant post was redesignated as an assistant law officer with scale of pay 5,500 to 9,000 with effect from 1/1/96. But it was given from the date of regularization. So the two persons, those who are appointed along with me, they are this honorable court. This honorable, as per this honorable court order, they were allowed the scale with effect from 1/1/96 notionally. So I approached the authority by the Annexure 7 and the agenda by the Annexure 8 was placed before the committee, but committee was passed a unreasoning order. It will be applicable to from the date of regularization. If your lordship kindly have glanced to the agenda at page 27. This was given by the secretary at page 27.
Yes.
Sri Manoj Kumar Mahanti was appointed as a legal assistant on ad hoc basis with effect from 1/7/1991 in the scale of pay rupees 3,050 to 4,590. The designation of a legal assistant has been redesignated as assistant law officer in the scale of pay of rupees 5,500 to 9,900 by the office order number such and such by 16/10/2007 in obedience to kind order of Honorable High Court. As per a decision taken by the board in its 243rd meeting held on 26/2/2008 by the item number 5, Sri Manoj Kumar Mahanti, the petitioner, appellant, who has been continuing ad hoc basis as a legal assistant since 1991 and subsequently as assistant law officer is allowed to continue as such regulations in the scale of rupees 5,500 to 900 from the date of issue of the order, that is 3/3/2008. As per order of Honorable High Court of Orissa passed in OJC number such and such, filed by Sanjay Kumar Pani and Sri Alok Ranjan Naik, two others, those who are appointed along with me, my lord. But OSHB, the designation of a legal assistant is redesignated as assistant law officer in the scale of pay rupees 5,500 to 9,000, and this order will come into force from the date of issue of their order with effect from 16/10/2007. Further, in view of the content petition filed by them in partial modification
why don't you come to the impugned order, sir?
Yes, sir.
The impugned order points out that you have not challenged the resolution.
That
dated 24/10/2009, and this is only consequential upon that resolution.
That resolution is not against me, my lord. As because your lord, in view of this honorable court order, agenda was fixed, but they passed the order without any reason. They were given also, they have not also challenged the resolution. But the two persons, they were given 1/1/96 with notionally. I pay also notionally, not for the not entire salary, for the purpose of seniority and others, my lord. Your lordship will kindly glance to Annexure 8. There it was clearly mentioned to avoid, and on the basis of the observation made by the Ometa advocate, it was opined at page 27, lordship kindly lastly, the same benefit to be given notionally from with effect from 1/1/96. But Annexure 9, that was rejected without any reason, That is under challenge. And the Lord single judge already passed the order. Your Lordship may kindly see. In view of the paragraph 409, in the 9, there was a mark that another writ petition challenging my regulation was pending. That if your Lordship will go through the counter that has been mentioned, my Lord.
Yes.
And that has been disposed of. That writ petition was disposed as the petitioner who had challenged my regulation order. He withdrew the case, my Lord. That is date 21/3/2017. And for law of equity, I am entitled for the same. Only notionally from the date of 1/1/96, as because I was getting the regular scale. That regular scale was a corresponding scale that was allowed from the date of a regulation. Since two other persons have been given the benefit from the date of 1/1/96 notionally, I am entitled for the same. That is my limited prayer, my Lord. Notionally.
Yes. Who's appealing for the state?
State Housing Board. Their panel lawyer is there.
Who's appearing?
And other cases also, in the similar cases by OSHB, the case was filed for the purpose of seniority. This honorable divisional judge held that since they are not appointed or continued for a stopgap arrangement, so they have to be given their seniority. And that was also before challenge before Honorable Supreme Court, and Honorable Supreme Court dismissed the same. I am just passing out through. That is the first seniority, my Lord.
Okay. This 19526, is it the correct one? No. 1976. That's why I'm getting confused. 19761. Yes, Housing Board. Yeah, it's never came up even once. Notice returnable. February.
Supplementary list item 29.
29. Your Lordship, may kindly allow me to conduct this case.
All right.
Yes. I am challenging minor annexure 7 and 5. Annexure 7 has been disposed of in confirming the order passed in annexure 5. My Lord, the petitioner is an association engaged in sports and other activities, and also every year they took permission from the municipal corporation to have exhibition come sale. They have applied for it under annexure 1. Your Lordship may kindly turn to annexure 1. They have been granted permission for 30 days for 960 square foot. My Lord, the price was fixed at 62,000 some odd. I have paid this price, and once again, when I applied for the income sale, they have issued the letter under annexure 3 that I have to pay 6 lakhs. My Lord, that is the sole thing which is under challenge, because they have, according to them, this has been issued keeping in view the notification of the municipal corporation that is on under annexure 6. My Lord, by the time annexure 1 was issued, annexure 6 was very much there.
But there's no estoppel on these things.
My Lord?
There is no stop on these things.
My Lord,
if they're supposed to demand it, they will have to, because of the existence of the earlier circular.
My Lord,
subsequently the assessment was revised and accordingly it was raised, my Lord. So
no, that is
no legal ground.
My Lord, that is not the case here. My Lord, your Lordship may kindly see notification is 7/2/15.
Yes.
And it was granted on 29/10/15.
Yes.
So much after the notification, this has been issued to me.
Yes.
And apart from it also, your Lordship may kindly bear with me. that Annex 1 was issued in favor of the association, but the demand has been made for individual shop rooms, from the individual shopkeepers, which is not legal. That is my prayer before your lordship. Because your lordship may kindly see the Annex 1.
Yes.
With reference to the subject cited above, I am to inform you that you are hereby allowed to install temporary stall on the size of so and so. And it was issued to Secretary Navodaya Youth Association.
Yes.
Whereas the demand has been made for individual shops.
Anyway, the person challenging you went as an association before.
Yes,
the
because association has taken the my lord permission.
So
since association has taken the permission
Yes.
for 960 feet,
Yes.
square feet.
Yes.
So it is the association who will pay.
Sir, the appellant here is the association.
Yes, my lord. That he is the association.
You're willing to pay.
My lord.
You're willing to pay.
My lord, willing to pay whatever has been demanded, I have paid.
No.
But right now they have demanding from each shop, which is not permissible because within 960 square feet, whatever shop is there, I have already paid.
If already paid, then don't.
My lord, then
why would they keep making demand?
As per instruction, they have not paid.
My lord, your lordship may.
There is no record also that.
Yeah, that they paid.
My lord, they have not filed any counter in other case also. So the honorable earlier also I had been to this honorable court, and the honorable court was pleased to pass an order directing to also associate me during the court hearing. They have formed a committee. Whatever committee has decided, keeping that in view, they have passed the order. If your lordship allow me to file another representation, that may serve also my purpose.
No. In fact, you were given only for a specific period. You've been carrying on shops endlessly.
My lord, carrying on shop, but who has given? Who has been allowed?
Yes.
And what was the area?
Yes.
That is the my lord issue before your lordship.
Yes. All right. The challenge, the present writ appeal, on 27th November 2019, passed by the learned single judge, dismissing writ petition civil 22640 of 2019 filed by the appellant association. Full stop. Paragraph. In the writ petition, the appellant had challenged an order dated 3rd November 2019, as well as a letter dated 11th November 2019, issued by the Bhubaneswar Municipal Corporation, BMC, through its commissioner and deputy commissioner. Calling upon it to pay ₹647,109, being the license fee, arrears of license fee for running temporary shops in the area allotted to it. Paragraph. The aforementioned writ petition was the second round of litigation before the single judge. Full stop. In the first round, the appellant had filed writ petition civil 3060, is it, of 2016, in which the learned single passed an order on 26th March 2019, directing the BMC to take a decision on the representation of the appellant. Paragraph. In the first round, the appellant had challenged the BMC resolution dated 30th December 2015, enhancing the license fee from rupees 400 to rupees 800 per day. First up. Pursuant to the order passed by the learned single judge, a committee was formed to examine the grievance of the appellant and submit a report to the commissioner. Full stop. That report revealed that initially the appellant had been allowed to install 2 temporary stalls for selling winter clothes inside the internal lane between quarter 7-17 by C and 7-16 by C in the Rajmahal Square for the period from 1st July to 29th August 2011. So this permission was renewed from time to time till 20th October 2014. Stop. The petitioner was paying license fee at rupees 400 per day for 80 square feet during 2014. Full stop. After the rate was increased to 800 per day by the BMC, the assessment was revised. Full stop. After adjusting the amounts paid by the petitioner, a sum of rupees 647,190 remained outstanding. Paragraph. The team that did the physical verification found that 24 temporary sheds were on both sides of the road in lane 1, unit 1, running the businesses throughout the year, although the allotment was a specific period only. Full stop. This was in clear violation of the terms and conditions of grant of allotment. Full stop. Paragraph. The learned single judge has observed that in view of the above factual findings, the demand raised for rupees 647,190 cannot be said to be unreasonable or unwarranted, and therefore has dismissed the writ petition. Paragraph. Learned counsel, the appellant sought to argue that individual shop owners were being asked to pay the enhanced license fee, whereas the allotment was made only in favor of the appellant. Full stop. On the contrary, the court finds that the demand has been raised only against the appellant, and it is the appellant which went to the court challenging the demand. Full stop. Therefore, there is no merit in this contention. Paragraph. The counsel of the appellant then sought one more opportunity to file yet another representation to the BMC for waiving the enhanced demand, waiving the aforementioned demand. So counsel of the BMC points out that the assessment was in fact revised after the enhancement of the rate license fee, and adjustment has also been made of the amounts already deposited by the appellant. Paragraph. Having considered the above submissions, this court does not proceed to interfere with the impugn order of a single judge, which appears to have proceeded purely on the factual findings returned by the team that was set up to do a physical verification. Full stop. Consequently, the court finds no reason to interfere. The writ appeal is dismissed. The interim order is vacated.
Supplementary list item number 30.
None appears dismissed.
Item number 31.
None appears dismissed.
Item number 32.
Same order.
Trace admission item number 33.
Item 32, my lord, kindly allow to withdraw.
All right. Dismisses withdraw.
Item 33.
33. Item 33, my lord, I have approached this against the
Item
33.
Item
33. By challenging annexure 1, my lord, that is the notice issued by the Joint Commission on dated 19 February. My lord, this is the relating to the period.
The same thing like yesterday we decided one matter.
Your Lordship.
Same audit report.
No, Your Lordship. In this case, this is 43 assessment, Your Lordship. And pursuant to the notice dated 19th February 2022, the petitioner appeared before the assessing officer.
No, but that actually was more than 6 months.
No, Your Lordship, it is not that.
From the date of the
it is 7 years.
report.
It is
More
7
than
years.
7 years.
And this proceeding has been dropped, Your Lordship. Your Lordship.
Oh, it's infructuous.
Your Lordship, pursuant to the notice, the petitioner appeared before the assessing officer and submitted all the documents.
In view of the subsequent development, where the demand itself has been dropped, the present petition has been rendered infractions disposed of as such. All right.
Item number 34.
May I interrupt, my lord? Sorry, my lord. May I interrupt? May I interrupt, my lord?
Which item?
Item 31. This is Union of India file a review application.
Tell us.
That's it. That is a order dated 31/3/2010. Margin requisition number 108/2003 has been challenged, has been displayed by now.
Yes.
Against which the union may prefer to file this review application.
Right.
Yeah, it is a case. May I pray, my lord? Can it be passed over after lunch?
All right.
Item 34.
Minus item 34. The petitioner opted for the SVLDR scheme, Sabka Vikas Legal Dispute Resolution Scheme, Your Lordships. And as for the SVLDR 3 issued, Your Lordships, the petitioner attempted 4 times for deposit of the directed amount, Your Lordships. Although the money has been debited from the bank account of the petitioner, in all the occasions, the amount was recredited to the account of the petitioner. Not so in the similar circumstances, my lord is in one of the cases directed to department to issue the SBLDR 3 FRS and also issue the SBLDR 4, Your Lord. So
that is
my lord placed the order before my lord.
That is not similar.
It is similar case, my lord.
No, my lord, it's not similar because he has no money in the bank, therefore it is returned.
No, my lord, I have the money with bank. It kindly have to annex to my lord.
Just a minute. I am suggesting, Lordship, here earlier one item 1144/22, your Lordship admitted in notice has been issued fixed on 23rd. So I am still Lordship admit and issue notice. So I return back on 23rd.
Notice, yeah. List on 23rd, is it?
Yes, as your Lordship.
He accepts notice for?
Formula the OP number
4. Not Centralex has come.
OP number, Milord, 4, 5, and 6.
And 7 also.
7 also.
4 to 7.
Yes.
Notice has to go to the remaining. I don't know.
No,
What is this Reserve Bank of India?
Yeah, bank has to go. Bank has to go. Because bank has returned back the payments.
Right, notice to the remaining respondents. But will you be able to serve it in such a short time? You won't be able to. Yeah.
Bank of India.
Returnable on.
But the statement by my brother is not correct. I was having the money and it was debited, subsequently been created, my lord.
That is therefore the revenue has not accepted the money, not
item 35.
Government funds.
Obliged.
Item number 35.
Item 35 permitted to withdraw. Matter is in progress.
Petitioner seeks leave to withdraw the present petition. Dismisses withdraw.
Item number 36.
Item 36 is similar to item 82, the batch, my lords. May I pray it may be taken up along with the batch?
All right.
Item number 37.
May I please your lordship? Here the petitioner has challenged the first appellate order under the GST Act.
All right. Same. You paid 10% already.
10% all, 10% and another 10,800
of the remaining tax. No steps shall be taken till the next date. Notice he accepts notice. Reply within 4 weeks. Rejoined for the next date. This turn. 8 March.
Item number 38.
May I please, your lordships. In this matter, your lordships, already the employer has deducted the TDS amount as per Annexure 2, your lordships, but they have not issued me the TDS certificate. My limited grievance before your lordships that the opposite party number 1 may be directed to issue the TDS certificate so that I am enabling me to get the state is the
opposite party
state is the.
All right. Notice he accepts and seeks time for instructions.
My representation is Annexure 3. Only that.
All right. The petitioner's representation dated 21st June 2022 shall be examined by the executive engineer. RW and S division. RW and S division. Denkana. Bracket opposite party number 1.
1, your lordships.
And after hearing the petitioner, the decision thereon will be communicated on or before 12th December 2022.
Oh,
no further directions are called for. The petitions disposed of. Right.
Supplementary stress admission item 39.
My lord, in item number 39, petitioner is challenging the inaction on the part of government for not waiving the proportionate MGQ on account of closure of shop due to COVID crisis. Government covered by your lordship order, my lord.
Yeah. Came on. 16.
My lord, item number 72 also similar matter.
All right.
My lords, item 45, 46 and 47 also similar matter.
All right.
45, 46, 47.
All of that. All right.
All right.
We can.
With your lordship permission, I have to consider. With your lordship permission, single bench matter, my lord, I am permitted to withdraw.
It's 10 of 2006.
You've gone through the affidavit.
Yes, we have given a convenience note for today. We have also taken note of that affidavit. The first issue is regarding that uploading of data by the prison department. They have somehow missed that. So there's a Supreme Court directive also that they may consider.
Right.
So it's only updated up to August.
Mr. Chabra, any reaction to that uploading of data?
Yes, sir. I actually reviewed the thing after the amicus curiae had told me. It seems that there was a problem with the website. We have been uploading it regularly. So after August, there is a problem with the website because our recruitment process is on. So a lot of applications were being received online. So it seems to have interfered. I am already in talks with NIC people. They will be sending their guy and it should be resolved in a day or so, and we will be able to upload the data definitely next week sometime.
All right.
Then the second one, my lords, is at page 2. It's regarding overcrowding in 2 particular jails. This is as per the figures of the State Legal Services Authority. They have given a particular compilation.
But those alarming 100%
those
plus
are
has
gone.
come
Those are
down.
gone.
Those days are gone.
But those are primarily for shifting them to nearby places.
Due to the intervention of Mr. Mishra, those days are gone.
So we can improve, my lords. Jajpur remains a concern.
No, in fact, Justice Raman had been to Malkangiri recently, and he saw the new complex coming up there. So I think
200 inmates.
so we'll have to follow up, like you were saying, the Police Housing Corporation.
Yes.
I think Mr. Chabra is also going to be holding meetings with them.
Correct. In fact, what I can share with your lordships is most of the things are on track, but this construction with this expansion, it has to just gather momentum.
Okay.
So there, if I was requesting if the MD of the State Police Housing Corporation, if he can be requested to remain present virtually. Then he can update, because that is something that's a bottleneck. I think Mr. Chabra may also agree with me.
Yeah.
But that is something which we are facing problems.
All right.
So, and then if those areas are actually capacity is built up, then it will resolve this overcrowding in those areas, because those are the areas identified.
Right.
And in fact, this is the problem we are dealing with since the last 1.5 years.
Right.
These areas.
Right.
So I think annexure BB by 1 at AB by 1 at page 19 is the reply to my learned friends.
Yes, in fact, I have factored that in. If my lord would see that document, the reasons that they are giving for the delay, if my lords would see that is at page 19 of the affidavit filed by the state. In that, they are saying some of the reasons given are due to shifting of materials inside jail premises. So they are not very cogent reasons, my lords. Shifting of materials within jail premises, that won't delay by, say, 4 months, 5 months. 2, 3, in some cases, it's 3 months.
We have also given the revised target.
Yeah.
By the end of this year, I think most of the constructions will be over.
Anyway, we'll ask them to be present on the next date.
Yes, ma'am. We'll give
because
the
some
update
of this
status.
Revised date is 15 November.
Yes.
We'll know that they were able to stick to that date. Some is 30th November and all that. So,
sir, I am actually also constantly monitoring it. There has been some delay from them, and I have impressed upon the CMD Housing Corporation to meet the deadlines. So hopefully things will improve. Some of the deadlines they have missed, and we are constantly monitoring this thing. So things will improve. I'll make sure of it, sir.
All right.
And next is this mental health and this doctors.
I think they themselves acknowledge that much needs to be done. In the affidavit I was reading, they're admitting that there are not enough psychiatrists.
Yes. So there also, that's another bottleneck I think the state is facing. So if the Secretary Health Department, if the concerned person can be asked to remain present virtually.
All right.
Because these are the two major bottlenecks, other things are in place.
All right.
Sir, in this connection, I would like to maybe just inform the Honorable Court that in the first PDB meeting, I had envisaged that the state is not having the capacity for psychiatrists and psychologists. So I had proposed the hiring of private psychologists and psychiatrists as consultants. So somehow in the first meeting, they said, let the state try one more time, but nothing improved. So in the second meeting, which was held on 4th, the minutes are also there. they have now agreed to the proposal, and I will be now, I am in the process now of doing that consultation hiring business. And hopefully within next few days, we will be able to finalize a panel of those private psychologists and psychiatrists. It may ameliorate the problem a little bit. And also I am in talk with Azim Premji Foundation, who have shown interest in this area. And they may also like to do something with collaboration from NIMHANS and others. So hopefully things will improve somewhat. If obviously the problem is complex, but we hope to have some kind of psychiatrist, psychologist visits and teleconsultations, which will help the situation to some extent at least.
All right.
Page 17. The resolution is very much there at page 17.
To the M's also. There are psychiatrists that can also obtain their help.
You were saying something, Mr. Padi?
Yes. I told that if necessary, then I can have a request to AIMS director. They have a psychiatry department. They can also extend their cooperation if possible. So,
all right.
If they require so, then
all right.
The other point, if my lords would see page 7 regarding publication of information.
You say it's in a remote corner in the site.
Yes. They have
prominence. But sometimes I feel it's better it's in the corner.
No, my lords.
Yeah, because this is not, people who are really interested in knowing will go there and see.
No, in fact, it's extremely remote. In fact, the additional chief secretary, he has also, in that page 8, he has mentioned that let them make it more user-friendly. I don't want it to be published in an open place.
Yeah.
But
make it user-friendly, is it?
Yes. They themselves have said that just follow up action on what the ACS has recommended.
That can be done.
All right.
But publication in
No.
This segregation of UTPs, why do you say it's not complied fully? What should be done?
So this what I gather from the DG prisons and all is that in areas where there is higher prison population, there is some problem with this segregation. But otherwise, in lesser places, they are doing it.
Okay.
So this has to be, they have to take steps because this is the, otherwise these people will become habitual.
Correct. Hardened people. Yeah.
So if in fact, that's the reason why I asked that if the MD Warehousing Corporation,
Police Housing Corporation.
Yes, Police Housing Corporation, if he can come down, then this once capacity is increased, then other things would fall in place.
All right. You say this court has perused the affidavit dated 7th November 2022 filed by the DIG prisons, as well as the note of the learned amicus curiae, convenience note submitted today by the learned amicus curiae. Paragraph. As regards uploading of data by the prison department, in terms of the order dated 7th May 2021 of the Supreme Court of India, in suo motu writ petition civil 1 of 2020, Mr. Chabra, the Director General of Prisons, who is present in virtual mode, assures the court that the data after August 2022 will be updated in a very short while with the assistance of the National Informatics Center. Paragraph. On the issue of overcrowding, it is seen now that both in Subjail Jashpur and the special Subjail Bhadrak, the percentage of excess population is 71% and 50% respectively. Full stop. Further, there are as many as 17 jails where the excess population is in the range of 20 to 40%. Full stop. The affidavit outlines the steps taken to increase the capacity of jails generally and refers to the ongoing projects to achieve that target. Full stop. Also enclosed with the affidavit, a chart indicating the timeline projected by the Odisha Police Housing and Welfare Corporation bracket OPHWC Bhubaneswar for completion of the different prison projects. Full stop. It is seen that there are as many as 21 projects with varying timelines, many of which have been revised and are supposed to be completed by the end of this year. Paragraph. The court would like the managing director of the OPHWC to remain present in virtual mode on the next date to explain to what extent the revised time targets as indicated in the set chart have been able to be achieved.
May I pray one thing to Lordship? Lordship may direct this communication of this order to him because he is not a party.
We'll get it communicated.
They have separate panel of lawyers.
Correct. Full stop. Paragraph. One area which is still a cause for is the availability of psychiatrists and psychologists to cater to the mental health needs of the inmate population in the jails. Full stop. Mr. Chabra refers to the affidavit where it is stated that the process of empanelment of consultant psychologists and psychiatrists is underway. Full stop. He expects that by the next date, there will be a larger number of mental health professionals available to the prison department to cater to the mental health needs of the prisoners. Full stop. A further status report by way of an affidavit be filed before the next date by the prisons department. When should we fix this next?
Short date, my lords, because that construction is something which is.
Yeah, but many of these dates in December. We'll have it in January, first week of January.
As your lord. Regarding the health secretary, if my lords would say.
That will file affidavit of, if required, we'll file the affidavit of ACS.
We can have it on the opening day, 2nd January.
My lord.
Or 2nd January.
My lord may keep it 3rd January. Just one.
There's already one medical matter on 3rd.
Okay. 4th.
3rd, 4th, 5th, there are matters.
And then it's okay.
All right. 2nd January. All right.
Regarding the health, because we are facing problems regarding the health.
Okay, you see, the secretary, additional chief secretary health is also requested to remain present in virtual mode on the next date. Then you say copies of this order be communicated forthwith, both to the MD, the Police Housing Corporation, as well as the additional chief secretary health.
That instead of MD, it would be chairman come managing director.
Or chairman come managing director. All right.
I'm grateful.
All right. Thank you, Mr. Jabra. Right. Yes.
Supplementary list fresh admission item number 40.
My pleasure. Lord, here I'm challenging the demand of license fee for the closure period, my lord. In fact, the on-shop of the petitioner was closed since April 2020, but after initiation of a cancellation proceeding due to pendency of a criminal case. Now, my lord has delivered a judgment that mere pendency of a criminal case cannot be a ground for cancellation of my lord, this license under section 47 of the Act. I have followed it in appeal and thereafter in revision. Now, both the authorities have acknowledged this and have made payment of my license fee subject to the outcome of the criminal case. Lord, my humble submission is that if at the first instance, merely because pendency of a criminal case, you couldn't have gone for cancellation, and that is how you have not allowed me to operate for this period, then the demand of license fee for this period is not justifiable, my lord. In fact,
what happened? The criminal cases are over, or
well, this is still pending.
So then what?
That is why the government has taken a decision. You deposit it subject to resolution. If this ultimately it will enter in acquittal, this will be adjusted with your future.
My lord, may I
then
just
there's no
give this-
This order is no way prejudice to the interest of the petitioner because it is subject to condition.
If at the first instance, they couldn't have initiated this cancellation proceeding merely because of pendency of a criminal case. My lord, may kindly turn to para 26 of this judgment.
That is perhaps not the subject matter of challenge in this writ petition.
Yes, my lord. Here also arising out of this Excise Act, a criminal offence was pending, and my lord, at paragraph 26.
Kindly see the prayer portion. Whether he has challenged the initiation of the proceeding itself. Initiation of the proceeding.
Kindly see the ratio. It may be added here that mere fact that a criminal case has been instituted against the petitioner will not per se disqualify him from holding an EP license. Learned counsel for the petitioner rightly pointed out Rule 35 of the OE rules envisages not granting a license to a person who has been found guilty within the previous 5 years of any serious breach of the conditions of his license, or importantly, to a person who has been convicted by a criminal court of an unbailable offence. In other words, mere institution of a criminal case against a person will not per se make him ineligible. So here, the very initiation of the proceeding for cancellation was wrong. So that is how they have kept my shop closed during the entire of 2020-21.
No, if he deposits the entire fee, will you allow him to operate?
I have already deposited, and for this onward after December 2021, they have allowed me to operate.
They are operating.
Well, I had deposited. So here my challenge is the demand to the demand itself. Because
the demand is subject to the outcome. It's not a...
They want refund. Kindly see the prayer.
Yes, my lord. I want refund. Yes, I want refund, my lord. If they couldn't have closed for their fault, my shop remained closed. So now they are demanding, in spite of that, you pay the license fee.
Because it's MGQ.
No, my lord, it's not an on-shop. It's in a case of on-shop.
Oh, I see.
So there is no question of MGQ, my lord. So the license fee. So because of your wrong action, my shop remained closed. So now can you demand the license fee for that period? Now they are made me to deposit, because without that I couldn't have operated. So it
may I submit one thing, if my lord. My lord, there are two things. Initiation of this proceeding basing on a criminal case, pendency of a criminal case is not correct. That is the ratio decided by the Honorable Court. But what is the prayer of the petitioner? Lordship may kindly have a glance over the prayer portion. Prayer is to declare that the demand of for the closure period in respect of so-and-so is illegal, and consequently direct the opposition refund adjust the license fee paid by the petitioner under protest. So they are not challenging that the initiation of the proceeding is bad in law. And that is why we are entitled to get the relief under this.
That is the entire basis of my.
No, your prayer is specific. You want it. You have already deposited. You have suffered the order. You have deposited the same. Now you are trying to refund it. Once you will allow your refund, then many people will say that, because in the similar principle, many vendors have deposited subject to outcome of the criminal case. If in the criminal, because it is a conditional deposit. So no prejudice is going to be caused to the licensee.
This second part of your prayer is already there. That is, adjust the license fee under protest.
But
they anyway are going to do.
Against the future fees.
That anyway they are going to do. That is the...
No, they have not done that. They have made me to pay. I have paid it. The revisional authority finally said, no, whatever you have paid for this period, that will be subject to the criminal case.
So what does it mean? So suppose you get acquitted in the criminal case.
Correct.
This will be
adjusted. That's there. But here I'm challenging, if because of your fault, your illegal action, I am made to pay something, then you have to part with that.
No, my respectful submission with your lordship is that
in any case, my lord,
the initiation of the proceeding is not under challenge in this petition. You have accepted it, you have deposited it. Government has ordered that your refund is subject to the...
In any case, my lord, I have exhausted the appellate and revisional remedy. If my learned senior wants to file a counter, then...
This is the point of law. If your lordship will say to ask me to file counter,
then my lord, I may rely upon two more judgments. This order is directed for refund. I may rely upon two more judgments, my lord, of this honorable court. My lord, here, my lord may kindly see.
It's all right. Then let him file a count. You say notice. Mr. Mohanty accepts notice on behalf of the opposite parties. All the opposite parties.
Yes.
Reply be filed within 8 weeks. Rejoined of the next. 14th March.
Obliged.
My lord, date
14th March. Item 41.
Item 41, my lord. Here I have paid for interchangeability to allow the interchangeability from beer, IMFL to beer, my lord. As per the.
You've given a representation.
that government is to take a decision, your lordship can direct that government will take a necessary decision on this, on his representation.
No, where is you make an application or what do you do? You made an
That is
application.
as per their own the direction, that is Annexure 3, page 14.
No, have you made a request to them?
I have not made any.
If they made a request.
I'll make a request, madam. I'll make a request.
All right. The petitioner states that he will first apply to the government.
To the government, because government is to take this.
Yeah, to the government for interchangeability of MGQ of IMFL in place of beer.
Next to say.
And after following up on such application, seek appropriate remedies as may be available to him in accordance with law. If such application is made not later than 5th December 2022, the decision thereon by the government will be communicated to the petitioner. Not later than 6th February 2023. Needless to state that if the petitioner is aggrieved by the said decision, it will be open to the petitioner to seek appropriate remedies in accordance with law. The petition is disposed of in the above terms.
Same. 42 also similar.
Same 42, yeah.
Item number 43.
My lord, item 43, the petitioner is a CL sub licensee. He has applied for surrender of his license, but the collector sit over the matter, not pass any order. My lord, earlier your lordship has passed this order, similar order.
There must be some lacuna. He must not have deposited the arrear duty or
deposited all the outstanding up to 31st March 2022, my lord.
Lordship may direct to consider his application. Same order can be passed.
All right. Same order.
Item number 44.
44, my lord, demand raised on account of unutilization of the MOA flower. I have already deposited the amount in the meantime during penance of the entire demand amount deposited.
Okay.
So nothing remains for adjudication.
All right.
Infructuous.
Since the petitioner has already deposited the entire demand amount.
Raised under Annexure 4.
Raised under Annexure 4, nothing survives in the present petition. It's disposed of.
Item number 48.
May I please, Your Honor. Here I have challenged the Annexure 3 demand notice, my lord. For the year 2015 and 16, where the interchangeability, with regard to interchangeability, my lord. I have lifted more liquor than the beer. They have adjusted it. But now they have, in the year 2022, they have made a demand of rupees.
But there's an alternative remedy.
Yes, he has to file appeal against this order.
This is a permanent order.
No.
Yes, yes.
Excise order. You see, page 30, the impugned demand notice is at Annexure 3, page 34, issued by District Excise Office.
On the basis
and
of
if he wants to challenge this demand notice, he has to prefer appeal
on the basis of the audit report, my lord, government audit.
But still, the appeal has to be filed against it. No? Counsel, the petitioner seeks leave to withdraw the present petition with liberty to challenge the impugned demand notice by way of an appeal as provided under the
Odisha Excise Act, or 252 of the Odisha Excise Act.
Section 252 of the Odisha Excise Act. Disposed of is withdrawn with grateful.
Supplementary for orders item 49.
49 minutes matter has become infructuous.
Item number 50.
It's a matter, Miller. This review petition has been filed against the order dated 7/9/2009 arising out of writ petition number 11647 of 2009, Miller. I have also filed. What has happened, this writ petition was disposed of at the stage of admission, Miller. without issuing notice to the petitioner. So finally, when the order was passed on 7/9/2009, but the same was communicated to the university, the petitioners on 4/5/2010. Thereafter, on 13/5/2010, this order was forwarded to the establishment ARC establishment. And in administrative level, it was discussed whether the order can be complied, the benefit can be extended to the petitioner and it is found that he is not similarly situated with the employees on the basis of which the order was passed.
So can we leave the question open, sir? After these many years, nobody's going to interfere
Yes,
with
Miller, I understand present question because what has happened, Miller, meanwhile, after the order was passed, he appeared for another selection for the post of assistant professor and he joined in that post, Miller. He may not have any grievance over to this.
Then don't press for this, sir. Don't press this review petition.
Because I have not taken any instruction, Miller, from the university.
Due to subsequent developments, the present review petition has been rendered infructuous and is disposed of as such. Right.
Item number 51.
None appears dismissed.
There should be no instruction.
Okay, no instructions dismissed.
Item 52.
None appears dismissed.
Item number 53.
The memo is taken on record. Dismiss is withdrawn.
Item 54.
Same.
Item number 55.
None appears dismissed.
Item number 56.
My lord, this is that case that it relates to Samali Mandir. The interim order has been passed declaring that they are not entitled to get the benefit under the 2000.
What happened in the Supreme Court?
That is pending, your lord, sub judice.
No, that is not even numbered.
Oh.
That is not even numbered.
I see.
They have only and your lordship may see that what is the date of the order of this honorable court, that is 12th July 2022. Already 4 months passed. And that is all not even numbered by this process.
Diary number has been assigned. Only the defect, after removal of the defect, the SLP number is given, your lordship. So diary, I am in a rejoinder also, in a subsequent writ petition, in the rejoinder, it has been mentioned, your lordships, that the diary number has been
given. But there's no interim order. What's the hurry?
No, my lord, what has happened repeatedly, I am respectfully submitting with your lordship. Because they are group of people and the writ petition is pending. They are saying that once our matter is pending before the Honorable High Court and we are to get or from the Honorable High Court will that let them come and negotiate with the district administration. And we are ready to pay adequate amount to them. Your lordship, the entire project is stalled. It is only for the benefit of the people of Sambalpur. The Samalai Mandir is going to be beauty. This is a beautification of Mandir, and like Chandi Mandir in Cuttack, there is a drastic step we are taking. And some of the encroachers who are having small huts and these shops, they are the petitioners before your lordship. And they are saying that we have floated a scheme, that is a government scheme or policy, and we are paying them adequately. And I have given a chart in my counter affidavit. Whatever amount we are paying to them, that is more than they are entitled to get according to 2013 Act. Only to the matter, and they are not allowing us to undertake the project work and stop the projector because of the pendency of the case in High Court, pendency of the case in Honorable Supreme Court. And if your lordship will see the order dated 12th July 2022 passed by this Honorable Court, the entire things are already explained by this Honorable Court. They are not at all, they are not the recorded owners. They are only the shopkeepers having shops nearby the Mandir and around the Mandir. And they are encroachers. We are paying them adequately under section what has been provided in the 2013 Act. Even if you are an encroacher, you are entitled to certain benefits. That benefits are extended. Like in all other cases throughout the state, we are providing benefits to the encroachers, and encroachers are vacating. Let them come and negotiate with them, take their money. And by this, they cannot get the permanent, your lordship may kindly imagine, they cannot get the permanent title over the property in question. By this process, they may get 10 rupee or 20 rupee. But they have to vacate this area. This is a government land. And so far, your lordship may keep it open that let them take the amount. If during adjudication of the writ petition, your lordship will say they are entitled to more than the amount which we are providing to them, we will give.
Madam, in my item, my lord, WPC 28562, 2022, my lord, not a PIL, my lord, but this case has been subsequently the assignment sent the matter to this honorable court, my lord, that has been tagged with this case, my lord. Here the case, my lord, the forefathers of the petitioners, my lord, they are residing there last more than 400 years, my lord.
This is also the
they
case
gave assurance that they will adequately provide the compensation. They have at all not adequately provided the compensation, my lord. Till yet, my lord, they have not given any money to the petitioner. Those substantial money is given, my lord. For that, we have sent a repression, and they assured us that there is.
Yes, it will be given. Your lordship may record my statement. If they are entitled to get, if they are dispossessed, if they are within the project area, they will be covered under the policy of government policy, which I have annexed in my counter affidavit. That also. And one thing your lordship can keep it open, that if they are found to be entitled more than the amount which we are giving to them by virtue of this policy, they will be given. But it's a matter of money, compensation, amount, not the title over the property. They have no title over it. Your lordship may kindly think it on this prospect. They have no right title interest over the property. We are going to
beg pardon, you will say we have a possessory title over that property.
No,
so we have been
encroachers have no possessory title.
The state is taking advantage of its own wrong.
Already decided by this.
They are very poor people. The state had the responsibility to give them the ROR. Because they have been residing there since more than 100 years. They are not
to remain present in the front side of the Samale. That is the one of the biggest.
That is not an endowment property, your lordships. They have been residing there. They are very much the part of the heritage and culture of the Sambalpur. They are
the entire public. Public at large, they want that this project work should be done.
Thousands of families are being affected, and how it is.
I'm prepared to argue the matter today. We'll hear you. You're prepared to argue. Let's proceed with the argument.
In my case, they have to give me the counter. They have already given.
No, that is a common counter. I can argue even if it is my counter. That is by filing one after the other cases with same argument, same allegation, everything is same, your lordship.
Some have been forcefully.
My case, forcefully. Now, your lordship, what forcefully? If the interim order has been vacated, are we not entitled to have
we have a right to.
Now you are saying that it is forceful. So this shows that they are refraining us, forcibly refraining the district administration, so that we will not be able to vacate the encroachers from the area in question and start with the project work. A huge amount of money has been government has assigned for this project, and for a few people who are encroachers, they are having small shop rooms at the cost of the interest of the people at large of the entire Western Odisha.
All of the inhabitants are
the Jagannath
in the connected matter. All the inhabitants are honorable.
That Samalai Mandir is like Jagannath Mandir in Puri in Western Odisha. They are the Samalai temple is the most and
no doubt.
We have beautification of that locality will be grow. We have nothing to say, my lord. Then, but they have to, my lord, adequately compensate.
Yes, we will compensate. That is, we will compensate. If this is not okay, then court will decide no, 10 rupees is not okay. You pay them 15 rupees. But that does not mean that you will rent the area.
That's why we challenge this. Without following
the basic intention is
that has already been answered in the order, please.
Everything is answered. Everything is answered.
And your lordship,
now how you are dedicating the same argument
that order with you challenge that at the Supreme Court. So that will await the outcome of whatever happens to the Supreme Court.
Lordships.
Yes. So why don't you start arguing the case?
He is also appearing for the municipal corporation, Sambalpur Municipal Corporation. This is a joint effort of this government for the development of the mandir.
Why don't we start arguing the case?
Some of the councils are not.
No, you are the main council.
Senior counsel, Mr. Pal is suffering from a attack, my lord, asthma attack. He's not stable enough to.
My lord, the only main writ petition is filed by my learned friend. He is that is the lead case. And if he argues
the lead case is your lordship, and your lordship are directed to make us party in the PIL. But till that we have not been made party in the PIL.
They want to circumvent the hearing. By this or that, they want to circumvent the hearing.
Okay, who Mr. Nayak is
My lord, I am appearing. My lord, I have already filed an IA for amendment impeding the writ petitioners in the application.
Where is that IA?
IA is 14703 of 2022. It was filed in on 27/10/2022.
It's not there. You filed a reply in the first one, 16945.
No, 1324, Rakesh Sunna, in Rakesh Sunna. That is covering everything. We have disclosed our case and we have annexed the policy. That is the only
It's not there.
Yes, my lord, I have got the number. This is the IA. That has not.
Just show us a copy.
On 27th October, I have filed.
Where is the filing stamp? Nothing.
My lord, that is my office copy, my lord. That is my office
copy.
copy.
Filing stamp, please.
You have
oh, yes.
token of filing. Acknowledgement. Receipt must be there.
Then let's put this IA 14703 of 2022. You see, this is an application seeking amendment of the writ petition. We implead all the petitioners in the connected writ petitions as parties. The reason stated, the application is allowed. The amended cause title is taken on record. Copies of this writ petition be served on all the impleaded petitioners through their respective counsel. The counter affidavit already filed in 13241 of 2022.
Yes, madam.
Is used by the state for all the petitions, including writ petition civil 28562 of 2022. Copies of the counter affidavit therefore be served, if not already done, on counsel for the petitioners in the accompanying writ petitions.
Only Mr. Dogad, I will serve on Mr. Others have already been served.
All right. It will be open to the parties to file the respective notes of arguments before the next date. Then you say it is stated that the SLP filed by the petitioners against the order dated 21st July.
12th July.
12th July 2022 of this court is yet to be numbered.
Yes, it is not yet numbered.
And listed in the Supreme Court. Full stop. And you just say list on.
My lord, last but not the least, may I pray that your lordship may record an observation that the state government may proceed with the.
Why should we? This is
because there is no
interim order. We have already
creating law and order. They are creating law and order on the ground of
that is up to you. The court will do what it has to do. There was an application for stay. We've refused. We vacated. So that's the end of the matter. Yes. We'll have it on 15th December.
One thing your lordship may kindly hear me for a moment. Your lordship may say that I am praying for this to make an observation that
No.
And your lordship may reject it. Your lordship may reject my submission by holding that since the stay order has already been vacated, there is no need to entertain this prayer.
It's all. We're not getting.
We can't do that.
Yes.
To that.
No, my prayer may kindly be recorded only. This is my prayer, and your lordship may reject it by saying that since the stay order is already vacated, so this court is not inclined to give any order. Sorry.
Yes.
My lord,
Item
may I be
57.
pardoned? My lord, the earlier direction was to implead the writ petitioners in WBC number 13,241 of 2022, my lord. Other writ petitioners I have not impleaded, my lord. I have only impleaded the...
Okay,
And
whoever
he
you
will
impleaded.
serve a copy to other.
IAS, whoever you've impleaded that, those IAS. That.
Oh, please.
My lord, may I request to last week of this month?
No. It's fine.
Item
Yes.
57.
My lord, this PIL reflects the distress and discrimination faced by the Telugu students in their studies in primary schools and high schools. They are not provided with books in their mother tongue in primary school from class
This
1 to class.
This representation you've dispatched it by what? By four?
I have represented from 2015 till date.
No.
We have been representing.
Sir, this last representation at Annexure 4.
Annexure 4.
What is there to show that it has been sent?
My lord.
What is the proof of dispatch of that representation?
Miller, Annexure 2 series, I have written a number of representations.
I'm on the last one, sir.
There are communications to the authorities from linguistic minorities community, even from the office of Vice President.
Sir, kindly answer the question I'm asking you. Annexure 4 is your last representation, correct?
Miller.
What is the proof of dispatch of this representation?
I am reading out the representation.
No. Please listen to the question carefully. What is the proof of dispatch of this representation?
Dispatch. Miller, I have already.
By registered post?
Yes, the receipt is there.
Where is that? Show us the receipt.
Pass on that brief. But don't clear. Pass on that.
This was
not this. You produce a proof of this. Do you have the proof of dispatch? This is 2015, sir. What you're showing us is 2015. This is a very old one.
2015.
What you are having in your hand, which you just now showed us, is 2015.
Annexure 4 is dated 25th February
It
2022.
is there. Lordship may keep it to other day.
All right.
I will.
At the request of counsel for the petitioner who wants to show proof of dispatch of the representation dated 25th February 2022. List on 29th November.
29th
November. Item 58.
29th November.
Item 58, November. 29th November. Item 58.
Not item 58, your lordships. On the request of the client, brief is transferred yesterday, your lordships.
Mr. Naik states that the brief has been transferred from him. Dismissed for non-prosecution.
Item 59.
59, your lordship may permit me to remove the defects and thereafter.
All right. What is the matter about?
It's
This again, defect 6 means you've not served a copy on the other side.
Okay. I'll just arrange for a copy, my lord, then I'll give it. Lordship may call it next week at least. This is against an appeal order, my lord, under the GST.
Okay, at the request of Mr. Karar. List on 29th.
Item 60.
May I please, your lordship? My lords, item 60 is infructuous, my lords.
Okay, dismissed as infructuous.
Item 61.
61 and 62, my lords, similar prayer, my lords. Your lordship may permit me, my lord.
29. All right. Defects put in the meanwhile.
61 and 62, my lords.
All right.
Greatly obliged.
All right.
Item number 63. Item number 63. 63.
The grievance petition of the petitioner annexure 3 is pending since 2020, my lord.
Make a fresh representation, sir.
My lord, annexure 3.
Make a fresh representation.
My lord.
Counsel of the petitioner seeks leave to withdraw the present petition to fresh representation, and after following up such representation, seek appropriate remedies in accordance with law. This post office withdrawn with liberty is paid for.
Item 64.
64 minutes. I am serving a copy of the writ petition on Royal Friend. Only item 6 is a defect minutes. Yesterday I couldn't get him, so therefore I couldn't serve.
All right.
Copy of the petition.
We'll call it then next week.
Next week.
Copy of the petition has been served today on Counsel for the State. List on 30th November. 30 November.
Item number 65.
May I please, Lordships, in this matter, I have a very small grievance before Lordships that concurrent proceeding under the CGST Act and SGST Act has been done. So my limited to advance my limited prayer, my lord, kindly have a glance at Annexure 1. Already, the central government, CGST department has proceeded against me, for which the non-payment of GST on royalty issue, for which again state government has issued me DRC 01, and that to that also I have replied at page 76, your lordships. Because already subjudice, I am placing the reply part, your lordships. Already subjudice before DGGI Rourkela, and due to technical glitches, the portal unable to upload the attachment. The details are already intimated to your Honor's office in manual petition dated 14/3/2022. It is therefore requested to you. So already I have informed about the proceeding before the CGST Act.
No, so what is it? I don't know what you want.
Only my limited prayer before Lordship that if the CGST department is proceeding, the let state because the section 6, subsection 2 and clause B of the GST Act bars the concurrent proceeding of the self-same issue by both the departments, center and state.
Your Lordship,
so if
your Lordship, there is no concurrent proceeding, your Lordship. Pursuant to his submission, notice has been issued and he has submitted that a proceeding has been initiated by the central GST. So state authority cannot initiate any proceeding. Your Lordship, pursuant to his submission, a letter has been issued to the central authority, and central authority has intimated that they are proceeding, they have dropped their proceeding. Your Lordship, the letter I have given.
Then it's infructuous.
But it is not.
But let me. Your Lordship, the letter dated 21st, yes, 21st July 2020 to the last para in this regard. Your Lordship got
To avoid parallel.
In this regard, to avoid parallel investigation, the investigation against Sri Nitin Kumar Agarwal is being closed at this end, and the qualification of quantification of GST and royalty paid to Government of Odisha pertaining to so and so and found during the investigation is hereby forwarded to your good office.
Correct. Counsel for the state, counsel for the state department has produced a copy of a letter dated 21st July 2022, addressed to the Deputy Commissioner of CT and GST, Sambalpur, by the Rourkela Regional Unit. Stating that by the DGGI Rourkela Regional Unit, stating that the investigation against the petitioner under the CGST Act, open quotation, is being closed at this end, unquote. So, in order to, open quotation, avoid parallel investigation. That way, the matter, the present petition has been rendered in practice since post office.
Your Lordship, let him appear because the date has been fixed. This letter has been communicated to him, and date has been fixed in the second letter, Your Lordship. And without appearing there, Your Lordship, this part has been intimated to the petitioner.
My only prayer before Lordship that Your Lordship may kindly clarify that the CGST, when CGST is not conducting this proceeding and only state is conducting that proceeding, the documents already have submitted before the center, they must have transferred to the state authority. So now they are issuing notices that you produce again and again all the documents that already have submitted.
The documents you must have produced
Only
originals, they are only copies.
Only yes,
copies.
Yes.
But I am appearing for 2 and 6 in this case. All right.
Second, also similar, Your Lordship, only difference is yes.
The so far as the second case is concerned, Your Lordship, the same copy, Your Lordship, here the state government has withdrawn that proceeding.
Oh.
Here, because it is the central dealer,
all right,
and central has been initiated.
Petition 19695/2022, Council, Mr. Mishra, Council of the State Department, states that the State Department has dropped proceedings against the petitioner, so that the proceedings under the CGST can continue. In that view of the matter, no further directions are called for. Petitions disposed.
May I request not he may appear before the authority as for this because of this order, because state has already withdrawn.
Definitely.
Correct.
Their objection may be given.
Definitely.
That objection may be given so that
no need, sir. This has to appear.
Definitely.
Item 67.
I may appear for OP number 2.
Or 67.
It's in item 67. 2 weeks time may be given to remove the
defects. Be cured within 2 weeks. List thereafter. All right.
Item number 68.
May I please, Your Lordship? Your Lordship, the petitioner has challenged the first appellate
Your Lordship,
authorities
order 20%.
20% has already been paid.
Or notice, he accepts notice, since 10% tax has already been paid at the stage of first appeal, subject to the petitioner paying 20% of the remaining tax. No coercive steps to be taken against the petitioner. List on, says that defects be cured in the meantime.
Your Lordship, with respect to the defect has already been rectified. We have solved the copy.
No, there are some other defects. Oh, there's only one defect, is it? All right, then you do remove that line. All right. List on. 8 February.
Obliged.
Item 69.
One time to comply the defect manually.
All right. Defects be removed within a week. List thereafter.
Item number 70.
70, my lord, the item became infructuous.
Infructuous. Dismissed.
Item 71.
Not pressed. Not pressed. Dismissed.
Hold on. 71. 71 not pressed.
Not pressed.
Item number 73.
May I please, Lordship? A virtual lord. The petitioner is granted with a license
I like
in the shop in a government land. Thereafter, he filed an application for shifting, and shifting is allowed after 3.5 months. That period, shop was closed. I have filed an application under Annexure 10. It is pending before the government for consideration of refund of my license fee and waiver of MGQ for that.
The petitioner's application at Annexure 10, dated 25/2/2022, will be considered by the government.
Government.
And a decision thereon be communicated to the petitioner not later than 1st February 2023. No further directions are called for. The petitioners dismissed.
Item 74.
May I please, Your Lordship, the petitioner grievances for shifting of his IMFL op shop, though required application was filled up and requisite fees were provided, no shifting has been done by the authorities, Your Lordship.
Where's the copy of it? Where's the copy of the application? Annexure 4 series.
Representation under Annexure 3, Your Lordship, and Annexure 4 is the application and the fees that were paid to the authorities.
When was it done, sir? 2/11/21. The petitioner's application dated 2/11/2021 for shifting of the off shop, is it?
Off shop, IMFL off shop.
IMFL off shop shall be considered by the government, and an appropriate decision thereon be communicated to petitioner not later than 1st February 2023. No further directions are called for at this stage.
Your Lordship, apart from that, there was also shortfall MGQ, the list
That is covered in your representation.
No, that is a different aspect, Your Lordship. We seek for the waiver of the liability also of that shortfall MGQ that they have raised during the COVID-19 period, Your Lordship. So we both seek that also, Your Lordship.
And waiver of MGQ.
Item number 75.
Obliged.
75, Lordship, I seek some time. Lordship, I issue notice. I'm not yet prepared this case because similar, all these questions are framed in similar issues. Not.
All right, at the request of Mr. Sarsuti.
Item number 76.
76, my lord, it appears a preliminary counter affidavit has been filed by Union of India without servicing a copy. I have already received the copy filed by the state government. So they will serve a copy.
Master Prabhu Prasanna Behra is met an accident. I think I will ask them to serve a copy. Let me give some time. Tomorrow day after to full file, because copy of the counter after his operation he is served on counsel with the petitioner. Already counter has been filed, man. Within 1 week. Rejoinder, if any, be filed for the next week. March. Obliged.
Supplementary item number 78.
The date is fixed, my lord.
Item 78.
My lord, I'm appearing on behalf of Mr. P.K. Rath for opposite party number 6.
1 minute. Who's for the petitioner? None appears for the petitioner. Dismissed for non-prosecution.
Item number 79.
My lord, 78.
Item 79. In this application, I made a two prayer regarding the irregularity of the financial and sexual act by the headmaster. To that effect, they filed the counter. I have also filed the rejoinder. As per their counter, my copy there is na? No. Huh? Give me. I've already served the copy. I have the receipt, my lord. I have not 79. There you go. And in their counter, it is categorically stated by their own document shows that there is a financial irregularity and the headmaster conduct the sexual act with the students, my lord. Lordship, kindly see the page 20 of their counter, my lord. May I read the page 20, last para? Page 20 of the counter filed by them. After going through all the statements and available documents, it is found that the web links was sent from the mobile of Dhirendra Kumar Naik, who is the headmaster of the school, headmaster of Perimon Academy, Cuttack, to the online classes WhatsApp group of class 5 students is true. And it is not at all useful for the students. The web link is an adult related link and it is connected with some naked photograph to the bra size of the breast size of some woman. It must have puzzled the minds of the
The pardon, your lordship, item number 78, your lordship. I'm sorry, your lordship, item number 78.
Yes.
No counter has come, your lordship. On 6/3/2018, notice was issued, and last time your lordship also asked to file the counter. But as of now,
Where were you when the matter was called out?
My lord, I was there, but I was not visible, audible, your lordship. My
No,
voice
no.
was not audible.
You were not there. We called out the matter. It's already been dismissed for non-prosecution.
My lord, I am sorry, your lordship. I was there in DC. I was there in DC. I couldn't be audible. Some problem in audio, your lord.
It's already been dismissed for non-prosecution. The other side was here, sir.
Yes. No counter has been received, your lordship. I'm sorry, your lordship.
Sir, the matter has been dismissed for non-prosecution. The other side is here.
Lord, I was not audible. I was there in DC, your lordship. I'm sorry, your lordship.
Yes.
Let them file the counter. Let them file the counter.
Item number 80. May I please, your lordship?
Yes.
So this is regarding the validity of the public hearing on a mining operation by opposite party number 8, my lord.
Yes.
Earlier, they have scheduled for public hearing. It could not be done because people came, time people reached this part, it was over, my lord. So they have to cancel it. Again, after 2 months, my lord, they again schedule another public hearing, but again, by raising barricades, huge public police officers, they obstructed the path of the tribals, major tribals, my lord. This is going to be affected 44 villages, and the people are large. While coming, my lord, the opposite party, they could see that they didn't reach the spot. Earlier, the timing was fixed at 11, and this
Mr. Party, you were to file the affidavit of opposite party number 6. What happened?
Yes. No, we have not issued them.
So all of them have filed counter, I suppose, my lord.
No, opposite party number 6 was to file.
Same problem is that
it's not common.
After matter action of Mr. Behra, I'm just helpless.
I have got a copy of it.
I'm not.
You don't have a copy.
I have not been served a copy of it.
You see, the affidavit of opposite party number 6 be brought on record, copy thereof be served and considered by the petitioner.
But here, if your lordship kindly allow me to see what, but because of the lapsing of the mining is not operation, because of this want of this DC, they have passed an order of lapsing. But that matter was also challenged. The Honorable Court says that unless this matter is taken up first, then that matter becomes redundant.
We'll try and keep an early date, sir. That's all we can do.
But if your lordship kindly,
because that affidavit is important. We had asked for that affidavit on the 2nd August.
I've got a copy of it. Your lordship,
I know, but it's not coming.
Let me fix a short date. But that my humble request.
We have already filed the counter, my lord.
1st December.
1st December, yes, ma'am.
4th December. Item number 4th December. Yes. Item 81. Interim order to continue.
Yeah,
interim order.
Fix it to end of the month.
1st December.
1st December. Grateful.
Item number 81. It appears from the cause list that Council for OPs 2 to 5 that they have filed certain additional documents, but without serving any copy on us. And besides, the rejoinder is ready. Your lordship may kindly.
All right, rejoinder the additional documents. Copy the additional documents filed by opposite parties 2 to 5 be served on considered by the petitioner. Rejoinder before the next day.
Item number 82.
Yes, sir. Your lordship may kindly see order dated 4/5/2022 belongs. Your lordship wanted to examine.
I have got also batch of matters.
There is hearing, where the hearing should be given.
My lords, here, what I pray, my lords, let Mr. Sahu complete his argument. I have no objection. But so far as my matters are concerned, and that should be segregated. from
Why?
him. Each matters may be different because the different
Yes.
is that.
And so far as my
Question of law is the same, sir, whether hearing should
no,
be put or
no,
not.
my lords, no, hearing by here, that is the, now, first of all, I guess your lordship is sleepy.
No, no, not at all.
Lordship,
Not at all.
my lords have already been exhausted.
No, no, not at all.
From
So
Samaleswari.
that, no, that gambit is not working today. You have to try some other line now. If you want an adjournment, you better find an excuse. Don't put it on the court.
No, I have got I know I have to, my lords, I have divided two cases. One group will sail through rough weather. Another group, my lords, they will sail through very, very in a smooth way.
So you already know where you are.
Yes. So I want to place first group which will sail through calm waters. And there is no rough water, not rough weather.
All right.
If your lordship may permit me, because Mr. Sahu, I know the judgment of the yesterday, lordship have already given a tip of anxiety to us.
No, that's a different subject, different issue altogether.
No, that I know. But in order to differentiate it, it requires some time. And so, my lords, what I suggest, it is like this. Those matters in group A, there are 4 to 5 matters. They don't require any investigation. They don't require any inquiry. That can be straight away, lordship may dispose it out. If your lordship will permit me, I will not go into that Punjab Haryana High Court decision, which has been confirmed by the Supreme Court. Again, that has been quoted in another judgment delivered by Justice Raman. I will not go into that. I will just point out in those cases that the proceeding itself is already vitiated and without jurisdiction. If your lordship will permit me, it will only take 5 minutes. One by one, I will place. It will immediately your lordship will.
Because issue is
Exactly. No. Different. No.
Same issue.
Same issue, not same issue. It is with me. I am.
If the facts involved in case
thing
of
is that, my lords, yes, it's different.
different argument. No problem.
अरे ये पढ़ रहे हो अरे आप वो सांगर ना वो against it. Then you go to that side.
Your lordship was to
Lordship, I am now pitted against a team of battery of Union of India lawyers. But I am a very small counsel. So to my left hand side, senior advocate is standing. I am a junior advocate. So I will only show the very, very small things which your lordship will immediately appreciate it, you will allow it.
All right. Let's start with at least one now.
Yes. One is, my lords, I will show your lordship. I will not also open it.
All right.
Lordship will kindly see.
Item 86.
That is Regency in WPC number 20533.
86. Item 86.
Item 86. Assessment year is 1617. Lordship found 20533 of 2022.
Correct.
Okay.
Right.
Now, my lords, notice your lordship will kindly see Annexure 1, page 9.
Yes.
My lords got it?
Yes, please.
Then reply your lordship will find. Annexure 2 at page 11, page 15 your lordship will find 9622. I have given the reply. 11 to 15.
Yes.
It is on the bottom. Page 15 bottom. 9622. My lords got it?
9622.
Yes.
Now, lordship will kindly see the date of order. 28/7/2022.
Correct.
Malus got it?
Yes.
Then Malus will kindly see 148 capital A small d. It says within a month this has to be disposed of, the reply. And here it is beyond that period. Just for a minute. 148 capital A small d. Small d. Small d. Malus got it. Within a month. Sir, within a month. Small d. Decide on the basis of the materials available on record, including reply of the assessee, whether or not it's a fit case to issue a notice under section 148 by passing an order with the prior approval of the specified authority. Within 1 month from the end of the month in which the reply of the reply is referred to in clause C is received by him. So here, the reply has been given on 9/2 and the order is given under section 148A(d) is 28/7/2022.
Yes.
Malus, Lordship knows the case of Commercial Motors and also Tirumala Industries Malus. The plea to time bar is also right. The plea to time bar, I am giving the judgment of the Supreme Court. And here no discretion is left. He has to act within that period. He has to dispose of. Lordship, I have given it a new. One is Commercial Motors Limited versus Amacopy. I would analyze. I would new. I just point out. Yes. Lordship, may see. First, I will take your losses to Tirumala Industries, Chemicals, para 20, page 38 of my compilation. An accrued right to plead a time bar, which is acquired after the lapse of a statutory period, is nevertheless a right. And here, on the face of it, the order which has been passed under section 148A(d) is beyond the time period. And this is a vested right of the assessee not to be reassessed. And your Lordship may kindly see, it has been followed by another decision of the Supreme Court at page 28, that is Commercial Motors case. Also, the Honorable Supreme Court has followed the earlier decision of the Supreme Court. That is page 28, Malus, Tirumala Chemicals Limited. They have quoted it and have accordingly proceeded it. So my respectful submission is, Malus, on the face of it, this doesn't require any investigation, no counter, nothing of that sort. It totally goes. No inquiry. As your Lordships have marked last year, the judgment of the Supreme Court delivered by Justice Chandrachud, that Saurabh Jain versus ABBP, which your Lordship have also followed it, that a point which requires no investigation, no inquiry, can be agitated at any stage, even before the apex court. So here, the assessing officer, having not disposed of within a month, is barred by limitation. This is number one. Then I'll give another judgment, another case. Someone.
my lords, WPC number 20073 of 2022. Assessment area 1718. Here, lordship will kindly see. Annexure 1.
1 minute. Number?
Number is, my lords, 20073.
Sambandh, Pincer.
Yes, of 2022.
Right.
148 capital A small b. Issued on 30th of March 2022.
30th of May.
Yes, 30th of May 2022.
Right.
Reply 13th of June 2022.
An order on 22nd July.
22nd July. Equally bad. Same argument matters. Then Pawan Kumar Jain. এই সংকলনটা কেন দৌড়ুন Pawan Kumar Jain. Yes, that is 19,474.
Item 85.
Item 85 matters. Lordship may kindly see the notice under section 148 capital A small b dated 24/5/2022. Is dated 24/5/24th of May 2022.
Your objection is 8 June
8 June 2022.
and 21st July.
Yes. Then order has been passed 21st of July. Base of it is manner powered by limitation of that section. And in Ashish Kumar Agarwala case, my lords, I may not repeat. Lords, you have so many times read it. That after complying the provisions or from section 148A to D, then issue of notice under section 148 shall be issued. There is no dispute about that. So therefore, my lords, at least I would have.
There are no judgments of other high courts on this?
They have not, so far as I have, I may be poor.
The department has some case law.
Let him complete.
No, you are.
I am appearing all the cases.
In all the cases? Yes. Okay. Sorry. I thought that another Chimanka, where he has gone?
All the cases transferred to me. I am appearing.
Okay. So you are the excellent counsel. Sorry.
Not like
He is now.
Your friend is here. Mr.
Chimanka. Yes. Mr. Chimanka. Now Nariman has taken place. Mr. Venugopal has gone.
Yes.
Okay, Mr. Nariman, please proceed.
Thank you for the compliment.
I always compliment. You take it otherwise.
No, not at all. Your Lordship, the basic question here is, so far the revenue is concerned, my Lord. First of all, the order is question whether it is maintainable under the read proceeding or not. That is the prime issue before your Lordship I have to argue. First of all, before your Lordship, see the 148A, I am reading it from the beginning because my senior is relying on the D only. Now, the 148A conducting inquiry, providing opportunity before issuing notice under 148. The assessing officer shall, before issuing any notice under 148, conduct an inquiry, if required, with prior approval of the specified authority with respect to information which suggests that income chargeable tax has escaped assessment. There is no question of approval. Approval is well within the of the argument. Provide an opportunity being heard to the assessee with prior approval of the specified authority by serving upon him a notice to show cause within such time as may be specified in the notice, being lost not less than 7 days but not exceeding 30 days from the date on which such notice is issued, and such time as may be extended by him on the basis of such application in this via.
PK Party? Ask them to come. Carry on.
Basis of application in this behalf as to why a notice under 148 should not be issued on the basis of information which suggests that.
One minute. Mr. Padi, you went through that matter.
My lord.
Item 31, is it?
31. Yes, item 31, yes, ma'am.
What is that?
It is a case, my lord. Yes, my lord. We are filing review on the order of the Honorable our High Court, praying there in that the order passed by the Honorable High Court. That is in because I entered document I don't have, but I got from LMS system, my lord. This is review application. The lordship may see period the order person last paragraph page 22. May I read, my lord?
Yes.
So far as the indigent condition of the family of the opposite party is concerned, we find that the certificate issued by the local tahsildar indicates that the annual income of the family opposite party number was 18,600, and we are in agreement with the tribunal that such income is not sufficient to hold that the family was not in the distress condition. Well, what happened in this case? In the death of the petitioner's father, he was minor. After attending the 18 years, after 6 years, he filed an application before this authority that I may be allowed to a rehabilitation appointment. Lordship knows it. The appointment on the ground of rehabilitation cannot be a condition, and they cannot claim that I was allowed to appoint.
There's no stay in this, Mr. Padi. There's no stay in this review petition. This order
there is no stay.
This order must have been implemented. It's 12 years ago.
My lord, no, my lord. This was I asked
for 12 years. You've not implemented the order.
I cannot give you.
Sorry.
So may I pray one thing, my lord? May I pray one thing, my lord? So my lord may keep it after 2 weeks. In the meanwhile, I take the instruction. And if not, and what is the status of the case? Then he joins somewhere.
We don't want it to we don't want this case to celebrate 13th anniversary. It's okay. 12th anniversary is good enough for this case.
My lord, I am sorry that it is a 2010 matter.
We'll create new records. We'll create records. Review petition pending for 12 years.
Yes.
New record.
That's why initially I'm not paying time.
It's all right. No ground for review. No ground for review, dismissed. All right, sir. Thank you. Carry on.
Yes. Basis of an application in this behalf as to why a notice under 148 should not be issued on the basis of information suggests that the income chargeable tax has escaped assessment. In his case, for the relevant assessment, a result of inquiry conducted, if any, as per clause A. I have already read out. Consider reply as a furnish, if any, in response to so cause notice reference B. Milord B. So in this case, Milord B has been complied with, reply has been filed. Thereafter, Milord, they concluded that the revenue will not pass a order on the 148 AB. Thereafter, 148 notice has been issued as per clause D of the 148A notice. I am reading out Milord D. Decide on the basis of the material available on record, including reply to the assessee, whether or not it is a fit case to issue a notice under 148, by passing an order with the prior approval of the specific authority within 1 month from the end of the month, if the reply referred in clause C is received by him. Or wherein such reply is furnished within 1 month.
Pause that slowly. Read that slowly. Within 1 month.
Yes, from the date of receipt of the reply.
Sorry. Why are you rushing, sir? Within 1 month. From the end of the month,
yes,
in which the reply is received.
Referred in clause C.
So suppose the reply has been sent on 8th June.
Right.
It should be within 1 month from 30th June.
Yes. 31st July. 31st July. Yes.
So that knocks off some cases of Mr. Rai.
But Milord, how is agreed by that? Even if assuming Milord, how is agreed by that? Assuming Milord,
how is agreed?
Milord, he has been filed a reply.
No, which means within 1 month has no meaning at all. No, this expression within 1 month has no meaning at all then.
Look, that was.
Why should the legislature put within
correct,
1 month?
Correct. That I understood, Lord. But as you stand here, Lord, order has been passed, Lord.
That's why they are here.
Yes. Therefore, Lord, my submission would be, Lord, that there is another chance of hearing to him, Lord.
When? For what?
148 also there, Lord.
You're making a mistake here. You see, the point is a good point.
Yes.
Because it's a point on procedure.
Yes.
All right.
Yes.
When it comes to the merits of that order, maybe the Punjab and Haryana approved by the Supreme Court will be coming in their way.
And Delhi also, Lord. Delhi also passed.
Whatever. But here, this is a question of procedure.
Yes.
This within 1 month can't be simply brushed away saying, so what if you have not passed within a month? After all, he's getting a hearing. That can't be the answer.
No, Lord, then Lord, the receipt by him or such reply is furnished within 1 month, the end of the month in which time is extended.
I think the point that Justice Raman is also making is interesting. Even when there is no reply, you have to pass within 1 month from the end of the month in which the time or extended time allowed to furnish reply as per clause expires.
Yes.
So he has got a time to file a reply. If he misses the bus, you go ahead and pass the order.
Yes, correct.
So either way, the limitation applies. Either way, the limitation applies. But this 1 month period begins from the end of the month in which he's filed the reply.
Yes.
Suppose he has filed it on 2nd June.
Yes.
Limitation will be from 30th June.
30th June.
Even if he's filed it on 29th June, it will be from 30th June.
Yes. 31st July.
Correct. Within a month. That's what the word used to is a month. Correct. So in the first case, which he referred to,
yes,
I think it's 20533, is it? Regency Inn. It's what was the date of your reply, sir?
In which reply?
My Lord, it is 9622.
So it's within a month. Within a month.
May I read in, Lord? Just my satisfaction, Lord. Kindly bear with me 1 minute, Lord.
Sir, why don't you just look at the dates?
Yes, no, before that date, not just.
There's no need to interpret them.
Just pointed out, Lord. Within 1 month, end of the month, in which the reply referred in clause C, then the date of the C reply has to be considered while counting the time limit.
No. All these. See, replies filed in June. In all these three cases which he's pointed out,
yes,
reply, the order has been passed before end of July.
What is objection filed on 28/7/2022? As Milord is enclosed.
Which case are you reading?
Milord, the Pavan Kumar Jain.
Which is his case? You stick to the case.
Number.
There are three cases he's referred to. You have to argue those cases, sir.
Yes, Pavan Kumar Jain. 85, Milord. Pavan Kumar Jain, WBC 19474. Yes.
Reply is filed on 8 June.
8 July, 8/7/2022.
June.
8 June, sir.
8 June 2022, Milord, Annexure 2.
Correct.
Yes. He has filed, Milord.
From the end of that month.
Yes.
That is from 1st July to 31st July, he has to pass.
Yes.
When he has passed.
21st July. So, which is why we're trying to tell you, we are trying to tell you something in your favor. I think you're not getting it.
No, I understand.
Now you understood. Since I used the word in your favor, you suddenly understood.
I'm not just.
You're unnecessarily arguing. There's no need to argue.
No,
because it's within 1 month from the end of the month.
Yes.
I am caught.
Now you slide down to Punjab and Haryana now.
I will distinguish. And now I will come to the main crux.
Okay.
So
this is over. This you can sit down now.
Now I think senior counsel.
Everybody will come back to Punjab and Haryana only now.
That's my argument in this case, twofold, Milords. It's before entering into the substantial question which your Lordship have posted the other day, asking us to give a reply.
Yes.
Whether 148A(b) contemplates of Milords oral hearing,
correct,
or Milords it can be taken care of by giving on the basis of so-called reply.
Correct.
Two options.
Correct.
But before going to that, Milords, I have had also judgments on that. I will place it for Lordship, Milords.
Yes.
Now, for a moment, the Lordship will kindly look at Annexure 1 at page 13.
Yes. Which case is this now?
This is the
9191. You are pressing 9191.
I am yes 9191. Okay.
Yes.
That's annexure 1 at page 13.
Yes.
Is a notice issued under clause B of section 148A of the Income Tax Act.
Correct.
Your Lordship will find from column 3 of the notice. I am required to give a reply on or before 15/3/2022. You may, to the extent technological feasible, submit a response with supporting documents if any other above mentioned issues electronically in e-proceeding facility through your account in e-filing portal at your convenience on or before 15/3/22. Now, my lords, this also encloses with one annexure giving the reasons why the proceeding is
being reopened,
proposed to be initiated. Your Lordship then kindly turn to page 15, my lords. I filed one adjournment application. That is also contemplated. Your Lordship found from 148 small d. I can also, I have prayed for an adjournment. And this was uploaded, my lords. And your Lordship may kindly see the report. Request for adjournment, my page 15, I am reading, my lords. Request for adjournment submission to notice 140 submitted successfully. This is a system generated email and please do not reply. So successfully, this is uploaded. On 15/3, that is the due date for filing a reply, lords. Then my lords may kindly see page 16, I submitted so-called reply and the report at page 20. First, your Lordship, page 20 and the context of the reply which I have filed, lords, that starts from page 16 to 19. Page 20, lords. E-proceeding response acknowledgement. Notice issued date 7/3/22, due date for submission 15/3/22 as per the notice, and now this is filed on 23/3/2022. Your Lordship may kindly see the date 23/3/2022. That my lords will find from page 19.
Yes, yes.
My lords. Now, the order which they have passed, also deciding to issue notice under 148A(d), lords, for purpose, lords, your Lordship kindly see page 22. The order is passed on 26/3/2022. That's while passing this order, lords, neither they have taken into account the adjournment application which have submitted, lords, nor the reply, lords, so-called reply responding to the notice filed annexure 1. Even though the order was passed on 26/3/22 and my reply was very much there on 23/2022, that was not considered, lords. On the principle of natural justice, only that I pray that the order should not have sustained, lords. One. Number two, in the counter, I have gone through, lords. My friend, which is in the counter, he has said, so far as paragraph 5 of my submission is concerned, regarding adjournment application which I have filed, and they have not recognized that in the order which they have passed. They say that the assessee is put to strict proof of the same. Because probably I may not have much proof than the proof which I have annexed by annexure 2. That is the very uploading report in their portal.
No, that's a request.
Email.
But that letter is also vague, sir. It doesn't tell us how much adjournment you sought. 1 week, 10 days, nothing it says.
For submission successfully. No, this is a report, lords.
No, your adjournment request itself is not there.
Adjournment request, lords, the application is not there. This is a report only, lords.
That's what.
The report
so we don't know whether you asked for 1 day, 2 days, 5 days. Nothing we know. Anyway, this is all not material. Now the order has been passed. Yes.
Now the order is passed on 26/3. My reply was there very much on 23rd March, lords. And
see, the purport of the Punjab and Haryana judgment is all these grounds can be taken up whenever you challenge the reassessment order.
Now, lords, going to that, lords. Lords, I will bring to Lordship's attention, lords, the relevant provisions and the judgments of the Constitutional Bench of the Honorable Supreme Court to the effect that, well, lords, what is opportunity of being heard? The language used, lords, under section 148 small d, lords, what is that? Whether the so-called reply on the basis of that, if that is considered, that will suffice for the purpose of 148 AD, or lords, opportunity of hearing does contemplate oral hearing. But that has been succinctly considered and decided, lords. And the one for the time being, just I am to clarify for Lordship, lords, the judgment which was brought to Lordship's notice yesterday, arising out of Punjab Haryana, my lords. In that judgment, 148A small b was not under consideration, lords. So therefore, that will not deter your lordship to enter into that question.
All right.
And
But 148A-D was being considered.
148A-D, my lords. That's your lordship, my lords, the question which your lordship
I know, is on D, correct.
Yes.
Correct.
By the order 452, your lordship.
All right.
Plus, now I will pray your lordship to kindly bear with me to place the relevant provisions. Kindly. First, let me place for lordship, lords, section 148.
Right.
Issue of notice where income has escaped assessment. Before making the assessment, reassessment or recomputation under section 147 and subject to provisions of section 148A, the assessing officer shall serve on the assessee a notice along with a copy of the order passed if required under clause D of section 148A, requiring him to furnish within such period as specified in such notice a return of his income or the income of any other person in respect of which is assessable under this act during the previous year corresponding to the relevant assessment year in the prescribed form and verified in the prescribed manner, and setting forth such other particulars as be prescribed, and the provisions of this act shall so far as may apply accordingly as if such return were a return required to be furnished under section 139. Then proviso is also equally important because the earlier language used in 148 like the reason to believe, now that is substituted by suggest, provided that no notice under this section shall be issued unless there is information with the assessing officer which suggests that the income chargeable to tax has escaped assessment in the case of the assessee for the relevant assessment year, and the assessing officer has obtained prior approval of the specified authority to issue such notice. Now I will descend to 148A, my lords. Once again, let us read together, my lord. Conducting inquiry, providing opportunity for issue of notice under section 148, the caption. The assessing officer shall, before issuing any notice under section 148, conduct any inquiry, if required, with the prior specified authority with respect to the information which suggests that the income chargeable to tax has escaped assessment. So this is the first limb of mandatory requirement of section 148, that whenever the assessing officer has any information, he has to, based on information, conduct an inquiry with prior approval of the specified authority bears. Specified authority also bears, that is provided under section 150, 150. So now I will take over. Now B, provide an opportunity of being heard to the assessee.
Item 89 and 90.
Sorry?
Item 89.
Not part of this batch.
89, yes. 89, my lord, yes. Form 8 public notice was challenged. I had submitted an application for on-shop license. In the meantime, during pendency of the development, government has considered and the shop has made functional since last 2 months. So nothing remains, my lord. He has unnecessary challenge.
You have to be petitioner.
C is for the petitioner. What?
I filed an IA for amendment challenging the issuance of notice. The IA has not been brought on record. The license has been issued to him. It is a conditional license, and it has been reflected in his license that it is subject
to license. Not in license.
It has been reflected
by the government.
It has been reflected in the license that
Are you aware of that subsequent development?
What has happened,
Yeah.
my lord? They filed the writ petition challenging the Form 8 notice, inviting public objection. During pendency of the case, license has been issued. Now she is saying that I will challenge. Let her withdraw this writ petition, file a fresh writ petition. That is
IA
better.
has not been brought on record. The file-
Without amending the writ petition, let him file a fresh writ petition challenging. Yes, that is better.
Shop was made functional since September 10th.
And on-shop.
On-shop.
Has been already made functional by orders of the state government. Can't the petitioner is permitted. The petitioner is therefore permitted to file a fresh petition Challenge the grant of license to the in accordance
Your Lordship, Pardon, Your Lordship, item number 90.
90.
Your Lordship, item number 90, the counsel for the appellant, Mr. KP Jaina has joined employment as public prosecutor. So the brief will be transferred, Your Lordship.
All right, counsel for the appellant states that since Mr. Jaina has been appointed as public prosecutor, alternative arrangements are being made. List on. What's the urgency in this matter?
Your Lordship, actually, I just received today only the brief.
What is the urgency?
263 order was challenged.
List in due course. List in due course.
All others are
Yes, Mr. Saab.
Pardon, my lord. Item 82. Pardon, my lord.
Pardon, Your Lordship. Item number
92, sub-item, WPC 1069 by 22, my lord. This is a not similar matter with the wrongly tagged with the single bench matter, my lord. Item 82, sub-item, WPC 1069 by 22.
So 1069, you say post before the list before the roster bench of the learned single judge on 28th November.
Obliged.
Now let's small b. Provide an opportunity of being heard to the assessee with the prior approval of specified authority by serving upon him a notice to show cause within such time as may be specified in the notice, being not less than 7 days, but not exceeding 30 days from the date on which such notice is issued, or such time as may be extended by him on the basis of an application in this behalf as to why a notice under section 148 should not be issued on the basis of information which suggests that if the income chargeable to tax has escaped assessment in this for the relevant assessment year and results of inquiry concluded, if any, as per clause A. C. Consider a reply of assessee furnished, if any, in response to the so-called notice referred to in clause B. C. Decide on the basis of material available record, including we also see the basis of material available on record, including reply of the assessee, whether or not it is a fit case to issue a notice under section 148 by passing an order with the prior approval of specified authority.
So just read the first phrase in each. B says provide an opportunity. C says consider the reply.
Correct.
D says decide.
D says material record.
No, decide. The crucial thing is decide. So first thing is provide an opportunity.
Correct.
C is consider the reply. D is decide.
And A is inquiry. What I believe is
no.
A is
that inquiry is what is happening.
Yes.
As part of the inquiry, first is you give a notice.
Yes.
See, you provide an opportunity of being heard by serving upon him a notice. So that the manner of providing the opportunity itself is indicated in that. How will you provide that opportunity of being heard? By serving a notice.
Yes.
And then considering the reply.
Because what is opportunity heard? That is crucial, Minos. There are three things, as your Lordship said, Minos. A is inquiry. Because inquiry cannot be given a go by.
No, it's not being given a go by, sir. How is it giving? In fact, this is the whole inquiry.
And outcome of inquiry will be taken into consideration vis-a-vis the information which he has in possession, Minos. That is one, A. That's B, opportunity of being heard to the assessee with prior approval of specified authority by serving a notice.
No. A is only the commencement of this whole inquiry process. A simply says you conduct inquiry with prior approval, right?
Yes.
B is how that whole thing is happening.
B is procedure to be followed.
No,
he has to issue a show cause notice.
B is that B is that whole, B, C and D is that whole process.
Yes.
Of A.
Culminating and D.
B, C, D are to be followed, my lords.
That's right.
B is minimum 7 days, maximum 30 days notice.
Correct.
Then, my lords,
no, we are now on the point of opportunity of being heard.
Opportunity.
You make a submission on that. What in this indicates that there has to be a personal hearing?
Correct.
There's nothing in this which indicates there should be a personal hearing.
So let me take my lord's attention to my lords.
Yeah, all that.
I am giving a judgment to lords. I have filed a compilation the other day, along with some judgment. And one more judgment I am adding to the compilation. Though this is a judgment of the Honorable Delhi High Court, but the Honorable Delhi High Court has referred to so many judgments on this particular issue. My lords may kindly see. I am taking your lordship's attention only to those judgments. That starts from para 11. Today, just now I handed over. Para 11. And counsel for the petitioners, Mr. Rawal and Mr. Nanda, relied upon Supreme Court judgment in.
No, how does the provision read, sir?
Sorry?
The question is second proviso to section 4 capital M. What is that 4 capital M? What is the wording of that 4 capital M? Now come to para 7.
Para 7 judgment, yes. 4 capital M, the Import and Export Control Act. That is a different enactment, Milords.
Correct, sir. We should understand the wording of that enactment. The question arises from that section only.
That section?
So what in that section has this wording?
Then your lordship may kindly see. You just put it here. Yes. Provided that your lordship may kindly see next page after paragraph subpara 2. Provided that an order enhancing or imposing, my lords got it. Provided that, next page, provided order enhancing or imposing penalty or confiscating goods or materials of a greater value shall not be made under this section unless the appellant has an opportunity of making a representation and if he so desires of being heard in his defense.
So the word and if he so desires.
So desires.
Being heard. So this whole thing is very different.
Yes.
Whereas here it says provide an opportunity being heard by serving upon him a notice.
Okay.
So the context of hearing there is different from the context of hearing here.
Then only I am taking your lordship's attention not to that but to the judgment referred to, which refers to what is opportunity heard.
Yes,
right.
yes.
May for a moment my lords may kindly see paragraph 14.
All right.
Paragraph 14.
Right.
Paragraph 14. The court, it starts from para 13. In the said case, the court has referred to leading English case, Rees versus Baldwin. In this case, it is held that good administration demands fair play in action and simple decorum in the front of natural justice. Para 56 says, normally natural justice involves the irritating inconvenience for men of authority to hear both sides, since notice and opportunity are its very barrow. And this principle is so integral to good government. The onus is on him to urges exclusion to make out why Lord Denning expressed the paramount policy consideration behind this rule of public law while dealing with nemo judex.
So this is not that doesn't apply here at all. It's only the second part of
second part, yes, audi alterum partem.
Yes,
audi alterum partem. Justice must be rooted in confidence, and confidence is destroyed when right-minded people go away thinking the judge was biased.
So it's even post-decisional, all that they say. Anyway, so this is all settled. This is all settled principles.
Then let me take your lordship's attention, my lords, as I understand important para 34. Para 34. Counsel to the respondent referred to relied upon PN, SOR, IR and others, registered Supreme Court of India. In this case, the court observed the importance of hearing and mentioned that courts are not caves nor clusters but shrines of justice, accessible for public prayer to all the people. Ruling need not be cited for this basic proposition, but every judicial exercise need not be a public show. When judges meet in conference to discuss, it need not be televised on Nations Network. The right to be heard, but hearing doesn't mean more than fair opportunity. The president wants a point of dispute followed by fair consideration thereof in a fair manner. Para 35 is very important. The court agreed that normal rule of judicial process is oral hearing and its elimination on unusual exception. Yes. So oral hearing. In that case, the court, while dealing with the wires of rule relating to review of the highest, your lordship may skip 36. Let us come to 38 minutes. Only paragraph 5 will be placing. 38. We have carefully examined the rival connections of the parties, contents of parties. We have also scrutinized the various lists cited by Law and Counsel in some of the contentions.
Actually, Ishwar Iyer, they said you can have review petitions by circulation. That is Ishwar Iyer.
Yes.
Supreme Court, they said you can have review petitions by circulation.
Circulation.
Even judges don't have to sit in the same room.
Correct. In review also that, yes. Now, on the basis of decision of Supreme Court, High Court and other English decisions, the ratio which can be extracted of all these decisions is that person concerned who has to pay duty and penalty should have a reasonable opportunity of presenting his case. Any decision taken without affording reasonable opportunity to the concerned parties would be already put in natural justice. The opportunity to be governed according to circumstances and domain of practicability as mentioned in Russell versus so-and-so. We are of the opinion that as far as possible, oral hearing must be given to the parties concerned. In the instant case, the decision of the concerned authority on the pre-deposit application.
Correct. Is vital because this decision would eventually determine the petitioner's substantive statutory right of appeal.
Correct.
So that's the context.
Yes, if that in the pre-deposit, it doesn't
That's right. If it can't be orally heard, it will never be heard.
Ultimately, the appeal will get dismissed.
Correct. This is not the context here. It's not even the beginning of the beginning. You have several rounds after this.
My lord,
Your Lordship will appreciate it.
And Mr. Chimaka has promised us to take Baljatra. And there is a match, very vital match going on, cricket match. So my lord, that confused me, and I thought that by showing some things I will clear. But your lordship have rightly caught me. Now what I pray, my lords,
I think
I will go for 2 hours.
All of you surrender to the Punjab and Haryana High Court.
Opportunity. I will take your lordship. This for 148, I'll take your lordship to the legislative history. Was not there in the 1922 Act. Was not there. What was there in 1922 Act? That section 34, which is in perimetry of section 147 now, there, while the assessing officer will notice that there is an escapement of income, in the same section, he will issue a notice. Now, this continued till 1957.
So we'll continue on 15th at 2 p.m.
2 p.m. Yes,
my lord. Another judgment of November.
List
Yes,
on 15th.
15th of November.
List on 15th at 2 p.m.
I have a humble prayer, my lord, sir. This item number 36 may kindly be also listed along with this matter.
Yes, yes.
And may I, subject to your lordship's kind consideration, lordship may protect me at least till that date.
From 15th, from now to 15th.
Lordship, I have handed over one judgment of the Supreme Court, which is carried out from the Punjab Haryana. He has considered AB 140 AB. Your lordship, kindly have a glance.
And you should appreciate, subject to what will fall from my learned friends and my senior milords. Here in this case, milord, we are giving your books of accounts also, milords. There are cases, milords, where for explaining the books of accounts, a personal hearing is necessary. Milords. In one of my cases, your lordship would appreciate, a partnership firm, milord, has been dissolved in 2016. Still, milord, they issue me a notice for 1819, and even though they notice that the partnership deed has been dissolved, milord, they still say that 148 notice has to be issued.
All right.
So may I just read my prayer, milord, for some protection, milord?
No, it's 15th. It's only on 15th. It's all right.
Okay. So let it come along with this.
Item 83.